Jake or Matthew, are you around? Just wanted to do an audio test here, just to make sure everything's working. Susan, who's making all the noise, I just want that on the record, public record. Right? Okay, and let's see. Oh, those were the two, they look like they're sisters that were sitting. Okay, I need to put the other. Okay, well, I thought I'd hear from them now, but they're not back yet. One, two, check, 1, 2. Let's see if I can get this working. Okay, 1, 2. There we go. It should be working now. Check, 1, 2, 1, 2, check. Check 1. Okay, 1, 2, check. 1, 2, check, 1, 2. You're still not going on. There we go. Check 1, 2. 1, 2, check. No, you don't want to stay on. Okay. There we go. Okay, check 1, 2. Check. All right. Do I need to turn this up a little bit? 1, 2, check 1, 2. 1, 2. Yeah. She's back. He's back. Everybody's coming back. You get a chance to enjoy the day, check 1, 2, and it's still deciding not to work because you turned off. Why did you turn off? Don't turn off. No, don't turn off. Check 1, 2, 1, 2, check. There we go. Don't turn off. Check 1, 2, 1, 2, check. Nope. Check 1, 2, 1, 2, check. And are you going to stay? You're just going to keep dying. Okay. Let's go. 1, 2, check. 1, 2. Let's see what 1, 2. 1, 2, check. 1, 2. There we go. Got it. Check 1, 2. Okay. Okay.
I think Kim's gonna come back. I was just eyeballing it to make sure. Yeah. 8 minutes.
farm that it used to just literally just be a berry farm,
Yeah.
and it was a restaurant.
Yeah, you got a hot mic issue there.
Good afternoon,
Sometimes if you can't
everyone.
afford Disneyland, you know.
I'm just checking to see Matthew. Can you hear us in Zoom?
Yes, I can.
Great. Okay. Chair Sabatier, I think we are ready when you are.
All right. Unfortunately, my computer crashed on my arrival here, and so it's popping back up. But in order to make sure that we respect time, let's go ahead and come back to order. We were on item 6.6, and Mr. Johnson, I'll let you finish your presentation.
Thank you, Chair. Do we want to dim the lights or?
Please. Thank you.
There we go. Okay, so moving on. So just to bring everyone back to where we were.
Oh.
All that great work that you did, right? Okay, F5. Showing up. Not working. It's not showing me. F5. That looks like it.
What'd you say?
Oh, there we go. Here we go. Here we go. It's this one. Sure, that's all. Okay. Not going back? Say what?
Do you want to use the navigation view too?
There we go. Okay, it just took a second.
Okay.
Sorry, but you can go to where you need
All
it.
right, I will.
Okay, sorry, it just...
Okay, so I'm going to cycle through here to. Okay, so just to bring everybody back up to speed, what we were talking about is the various ways in which the project description, which is the basis for the initial study mitigated neg deck, does not provide the adequate level of detail and does not include all aspects of the project as required by CEQA. And so this particular slide focuses on the failure of the project description to describe hoop houses and the use of generators. So we've already touched on this in our earlier history of violations, but this issue again relates to the failure of the project description to include a description of the use of hoop houses, the construction of those hoop houses, the use of fans, and the use of generators to power the fans and electrical in those structures for the purposes of drying cannabis. And the importance of this is that without those details being provided in the project description, the initial study, just as a matter of law, cannot provide an adequate analysis of the potential impacts related to those project components. Another inadequacy in the project description relates to lodging and the number of employees. So as between the initial study, the project description, the actual body of the initial study, I should say, the traffic memorandum and property management plan, there are multiple descriptions of the number of employees that will be on site at any given time for this project. Included in that is multiple variations on how many employees will live on site. At some point, there's a description that approximately 10 employees are anticipated to reside on site, and between 30 and 40 employees will be on site for 22 weeks of the year, with the potential for up to 65 part-time employees. Other portions of the document state that up to 50% of employees will be living on site. And again, what we're getting at is, what is the correct number? And those numbers relate to whether there are adequate facilities on site to house 50% of those employees, how does that change potential traffic impacts, and other aspects of the project that may result in unanalyzed environmental impacts. Moving on to traffic impacts. So this is a photograph of High Valley Road leading toward the project site, and we can see a tractor trailer that has gotten stuck on High Valley Road. High Valley Road is a recognized traffic hazard, especially for larger vehicles like this. Related to traffic impacts, again, the project description estimates that the average daily trips, vehicle trips, would be 40 to 80. But in that quantification, we only understand the document to analyze potential employee trips. There is no discussion relating to delivery trucks, vans, vendors, lunch trips. All the variety of trips that a project has the potential to generate are not described in the traffic impact analysis. We also really question this idea that there would be 20 to 30 employees with up to a maximum of 65. Based on my experience and based on the county's experience, an average employee count for a project like this would be between 2 and 3 per acre. So for a project of this size, we would expect to see an employee count of between 160 to 240 employees, with associated trips being multiples of those numbers. So there's insufficient information in the project description regarding the actual number of trips that the project will generate. These are some additional photos of trucks moving up High Valley Road. Again, they do cause hazards. They do have difficulty navigating. There's no analysis in the project description or in the initial study regarding these potential hazard impacts. Turning next, grading. Another element that hasn't been described in the project description. The project description states that there would be no earthwork or grading to prepare the ground surface for growing cannabis. That's just what's in the initial study and in the site preparation and cultivation plan. We've already gone over multiple photographs and evidence demonstrating, however, that significant grading, significant earthwork was performed in preparation for cultivating on the project site. And in fact, this activity led to enforcement activity by CDFW. So let's turn to the fair argument standard. So a mitigated negative declaration is permissible only when an initial study demonstrates with substantial evidence that after incorporating mitigation measures, a proposed project will clearly not cause any significant effect on the environment. By contrast, an EIR is required when there is a fair argument based on substantial evidence that a project may cause one or more potentially significant impacts. An M&D is inadequate, relevant to this appeal, in two circumstances. The first is where it lacks substantial evidence supporting a conclusion that after incorporating mitigation measures, a proposed project will clearly not cause any significant effect on the environment. And an M&D is also inadequate if substantial evidence in the record supports a fair argument that the project may have a significant impact on the environment. And this is important, even if competing evidence suggests it may not. So today's discussion is not about who's right. Today's discussion is there substantial evidence that's been submitted by the appellant, by other neighbors, that indicates there is a fair argument that the project may have a significant impact on the environment. If the answer is yes, regardless of what evidence has been submitted to the contrary by the applicant or developed by staff, the county is required as a matter of law to proceed to prepare an EIR and cannot adopt an ISM&D for the project. The deficiencies with the project include inadequate analysis of the following components, as we've discussed: air quality and emissions, water availability, biological resources, transportation, land use compatibility, energy and greenhouse gases, and noise. With respect to air quality impacts, and again, that is an actual photograph of dust being generated by the project, the initial study fails to analyze air quality impacts, including impacts from dust, odors, and greenhouse gas emissions. What you see here is the sum total of the project's analysis of air quality impacts, and on the basis of this data, the ISM&D conclude the project would not have a significant impact. But there was no analysis for grading activities and dust resulting from those grading activities, no analysis of emissions from the use of generators, no analysis of why odors from the project operations would not detrimentally impact neighbors. These air quality impacts, I won't try to read these, they're too small even for me, but these air quality impacts have been documented and provided to the county from neighbors over the course of months. Those complaints do constitute, as a legal matter, substantial evidence showing that ongoing air quality impacts were not analyzed or mitigated. As I said before, there were numerous neighbor complaints regarding odor and dust, and the ISM&D fails to analyze the use of generators, for example, to dry the cannabis. Impacts to water availability. So the ISM&D fails to adequately analyze several aspects of water use and water availability. I won't go into detail on all of this. I've already mentioned that there is only data provided regarding the production from well number 4. That data indicates adequate water to serve 25 acres of cannabis. There is no data provided for the production of groundwater from well number 7. So as a matter of fact, the record lacks any evidence that that there is adequate surface water, adequate on-site groundwater to serve the project. There just is no evidence supporting that. We also know that the project is now using Brassfield estate water for project activities. Even if that water is not being used to irrigate cannabis, if it's being used to irrigate sunflowers, which are being used as a mitigation, whether a visual or an odor screen, that is part of the project. It must be analyzed. In terms of the groundwater aquifers, I won't go into the details here. The letter that we submitted includes an attachment from a qualified hydrogeologist indicating that there is serious question about the validity of the groundwater analysis provided for the project, and providing substantial evidence indicating that the actual water availability may be far less and that the project does have the potential to result in a significant impact. This slide deals with well yields. I've already talked through those. I won't do so again. Brassfield water, same thing, raising the obvious questions. As I said before, from a CEQA perspective, it doesn't really matter whether the water is being used to irrigate cannabis or to irrigate sunflowers, but I think we all need to look closely at whether and why such an extensive infrastructure and piping system would be installed in order to irrigate a small acreage of fairly drought-tolerant sunflowers. I would also note that if you view the video regarding the water system in this presentation to the end, you'll see how the water pipelines tie into the main irrigation distribution system for the cannabis project. So, going to a fair argument here, not only have we submitted substantial evidence from a qualified expert, we also have comments from neighbors. And I do want to point out that while substantial evidence typically requires commentary from experts, CEQA and case law interpreting CEQA have identified the validity of opinions from non-experts, including neighbors on a variety of impact areas, including water, odor, traffic, and aesthetics. And so non-expert neighbors can submit testimony that qualifies as substantial evidence, indicating that there is a fair argument of a significant impact. Impacts to biological resources. So the ISM&D fails to provide an adequate analysis of impacts to biological resources. This relates to the failure to provide a wetlands delineation regarding the potential jurisdictional features that the project potentially may impact. And we also know that there were no floristic surveys, which are protocol level surveys performed for special status plants on site. As the county planning department well knows, floristic surveys are routinely required for all other cannabis projects, and why one was not performed for this project is an open question. So impacts to biological resources. Commentators, again, provided comments indicating the lack of biological surveys. This was prior to the July 22 Planning Commission meeting. Again, the county had plenty of information to determine that, in fact, protocol level surveys had not been performed for this project. Transportation impacts. We have provided with our commentary a peer review of the transportation analysis prepared by a qualified traffic engineer, indicating that the traffic analysis prepared for the project fails to meet required standards, and also demonstrating that there is substantial evidence supporting a fair argument that there may be a significant impact related to traffic, particularly relating to the number of vehicles and hazards on High Valley Road approaching the project site. This slide details again the various reports given between the ISM&D, the project description, the property management plan, and also the applicant's own testimony relating to the number of employees that would be on site. I can say that there is a significant degree of variability which impacts the significance of the potential traffic impacts from the project. There's no way to quantify those impacts without a consistent count on how many employees, vendors, deliveries, etc. will be involved with the project. Related to the VMT analysis, there is discussion regarding OPR guidance. It's a technical memorandum that OPR adopted. It's not a formal regulation, but it accompanies recent changes in Appendix G to CEQA relating to traffic impacts and the movement from a level of service analysis to a VMT analysis. And the OPR technical memorandum states that generally a project that involves fewer than 110 daily trips, not average daily trips, but daily trips, generally will not result in a significant impact relating to traffic. But it's not a hard and fast rule, and always site-specific analysis is required. I also do want to point out that though some traffic engineers are using, and project applicants are using the concept of an average, that word does not appear in the OPR technical advisory. So if we were to read that document strictly, if a project produces more than 110 daily trips, period, it should require a more detailed level of analysis for its potential traffic impacts. I won't attempt to read these, but these are more neighbor complaints regarding traffic from the project. Land use compatibility. So Richard Knoll touched on these points. I won't belabor them, but the point is that we have ample evidence in this presentation, photographic evidence. There are many, many neighbor complaints that have been submitted that indicates that the findings required to support issuance of this use permit simply cannot be met. The project is, as a matter of fact, adversely impacting the health, welfare, and safety and property values of the neighboring property owners. These are additional comments from neighbors regarding this issue. Impacts due to unanalyzed project components. We've talked about this at length. The ISM&D simply does not analyze impacts relating to the construction, installation, operation of hoop houses powered by generators with fans, period. So finally, we come back to what we had originally asked the board for today. We asked that the board grant the appeal, deny the project. We ask that the board direct staff to immediately abate all current project activities, not in 30 days. And we ask the board to direct staff to prepare and circulate an EIR for the project. Now, I am concerned that staff may be intending to approach this project by bringing it back to the board if and when the project applicant abates the current violations on site. But I do want to underscore that a denial today of the project is a formal denial. It is not a temporary denial that allows the project to be brought back. So if the project applicant wants to abate those violations, resubmit an application, and pursue this process again with an EIR, that would be the required and appropriate approach. So we thank you for your time and certainly appreciate the opportunity to fully present this today.
Thank you very much, and we'll get to questions when we've accomplished all of our presentations, and I wanted to offer the applicant opportunity to present.
For the applicant. Mr. Armstrong is here. He's with the applicant's team. He has a PowerPoint presentation he's going to get set up. I also have some remarks, which I would like to make standing here, if that's okay with everybody.
It's perfectly fine.
Yeah, this is good.
I don't know if I should. How's that? Does it make a difference?
I have it off.
Oh, it's off. I also need to speak loudly.
Now let's wait because we want to make sure that everybody, whether it's on PEG, Facebook, or Zoom, can hear.
Understood.
Sam will let us know when we're ready.
I'll need him to reintroduce himself too. We don't have it on the record yet.
To the left, right there.
Is that it?
Yep,
Okay, great. Sorry, I just can't see it.
right there.
Thank you. Okay, and then to go forward,
Gotcha.
go backward. Okay?
And let's wait for him to turn on your mic.
And talk directly. If you're going to talk directly into the mic. I will turn yours on in a minute.
Okay.
And if you can start over with your introduction since you were not heard.
Okay, could we please have the lights on for this portion? I'll just be speaking, and then Mr. Armstrong will follow up with some photographs and a PowerPoint slide. So again, my name is George MacDonald. I'm an attorney with Katzoff and Riggs. I represent the applicant in this proceeding. Now, last time we were here, just a few weeks ago, there was a continuance requested. And I came up and... Okay. Thank you. And I came up and said, nothing relevant or new is going to come to light as a result of that request for public documents. Well, in a sense, that was true. Nothing relevant to this appeal came to light. Everything really that was discussed today pretty much was known, was decided on, was brought before the Planning Commission when they approved this project 4-0. However, what has become clear is that Mr. Johnson, he has some conflicting interests here. There's no doubt about it. He stated in writing before...
I'm going to interrupt because I want to check with Ms. Grant because the project is what we're discussing today, not the people who are the applicants themselves. I don't want to judge the applicants on their personalities or anything like that, and I just want to check in that that is something that I can narrow the scope of.
I think that your board can request an offer of proof as to relevance for something like this, because ultimately, and again, I know I'm beating a rug here, but This is a de novo proceeding, and your board has to make the findings for a major use permit under 51.4 of the zoning ordinance, and also those specific findings that relate to cannabis under 27, I think it's 2713 AT of the zoning ordinance. And that is the function of your board here, to determine if you find motivation somehow impacts those findings, that's one thing, but your analysis again begins anew, so what's happened in the past may not have great relevance. However, again, this is an administrative proceeding. Your board may take in a great deal of evidence that would not necessarily be admissible in a court of law, and you determine how much weight to give that evidence. Before your board begins deliberation, I'm happy to explain a few points on that for you that you may find helpful in terms of weight of evidence and how you may go about it. Certainly not a direction, just an option. So at this point, again, an offer of proof would ask counsel to be able to show you why what he is about to say has some relevance to your board's determinations as to this appeal. And again, because you have to independently make these findings for a major use permit and the findings required for a cannabis cultivation site. Again, he'll have to make the showing to your satisfaction.
So thank you, and please make sure it's connected to the appeal itself.
Absolutely, and I'm happy to say right now why. It gets to the aspect of allegations that there's some type of, that there was not impartiality, or that there's some type of favoritism, or that there was improper communications. But really, what this Public Records Act request disclosed was that it's not just the Sowers team that asks requests of the Planning Commission. It's not just the Sowers team that asks requests of the supervisors. Mr. Johnson did this exact same thing for his projects. Mr. Johnson repeatedly asked for why are ours and log jams and the Sowers are not with respect to Bar X and Lake Vista Farms. There was no impartiality. It was, the evidence shows actually, for what was produced in response to the Public Records Act request, that everyone was treated the same. There was, I believe, 33 projects in the exact same circumstances at the exact same time. And what the emails showed, and what was actually given as a response to Mr. Johnson in answer to this question, well, the Sowers team has been extremely proactive. They've been extremely thorough, and they've been extremely on top of it in submitting what we've asked for. And when there was any type of issue, you know, this may be a problem. They didn't fight about it. They didn't hire an attorney to send emails to everybody saying, why are you doing this? They said, okay, whatever satisfies the commissioners, whatever makes it easier for the neighbors, that's what we're going to do. And that's really what the Public Records Act request responses showed. Now, I know the appellant here, they've cherry-picked a lot of text messages and different things like that, taken them out of context, and attempted to say that they prove things or say things that they, frankly, do not. And that's going to be my next point. What has occurred here today is basically textbook of dirty litigation practices. And if this were a court, which it is not, none of this evidence would have been allowed in. None of these statements would have been allowed in. This is essentially a trial by ambush, is what the Bradley firm has attempted to do today. I believe it was last night around 4 p.m. They submitted 160 pages of documents, a lot of photographs, things like that. There's no indication who took these photographs, where they're from, what time they were taken, nothing of the sort. In fact, some of the photographs we saw here today, with respect to the grading practices, were of different properties. They weren't even the same property. And that is shown, we don't have them up here right now, but it becomes quite obvious once that pointed out, right? We're talking about a project in a valley. The photographs with large mound of dirt, those were on top of a ridge, somewhere completely different, which looks like Mount Canocti in the background. We're talking about High Valley, completely different area. So, a lot of this information that's been presented today was intentionally misleading, intentionally manipulated. The videotape of the dust that is sped up and taken at dusk with zoomed in angles, I mean, textbook manipulation. That's exactly what it looks like. That's how it's done. It should not be considered. This information should not be considered. When, you know, one of the first points the appellant makes in their letter that was submitted last night one of the first points they say is some type of hyper-technical argument that makes no sense, that since there was an appeal filed, that EA was terminated. Well, that's not true at all. That's not how things are intended to work. That's not how they work. Of course, if the use permit was stayed, so was the termination of the EA at the same time. That's how it works. And as we've already discussed, planning pointed out, this is not an appeal of the EA. It's not contemplated. It's not discussed. Nowhere is it discussed in the actual appeal documents that were filed. Now, moving on, I'll get now into the substance. So there's been some positions or some statements saying this is not the proper place for cannabis to be grown. Well, when you drive out High Valley, one of the first things you see is a big sign. Welcome to the High Valley Agricultural Area. Welcome to the High Valley
Wine, grape, growing appellation.
So everyone here agrees with me, this is an agricultural area. In fact, it is zoned ag. And everyone knows when you purchase property located next to agricultural properties in California, you get a huge packet of disclosures stating, in California we have the Right to Farm Act. In California, farming activities are not a nuisance. In California, you should expect, when you purchase property next to agriculturally zoned land, you should expect potential agricultural activities, including dust, odor, noise, and everything that is incidental to agriculture. That's what's expected when you purchase property next to an ag property, and that's what we're dealing with here. The cultivation site is zoned agriculture. And that's indisputable. And now, talking a little bit about High Valley Road. In all relative respects, High Valley Road's a pretty good road for Lake County standards. In my understanding, it's completely 4290 compliant. There's no issue at all. As far as permitting and things like that, there's no issue with the road. And it reminds me somewhat of Soda Bay Road. When I was driving here today from my house, it reminds me somewhat of Soda Bay Road going through Big Valley. Albeit, to get in, it's a bit more windy, but it's a similar type of atmosphere. There's agriculture. It's a 2-lane road. And now, we've seen a lot of discussion and photographs about traffic and trucks. It's not clear that any of these trucks are in any way connected with this project. There's a lot of other projects going on. There's Brassfield Winery, which is an actual winery, and they have events and weddings and things like that, is my understanding. There's other types of operations, there's other vineyards, there's a lot of things going on. To say that all this traffic is a consequence of this project here is just false. It's important to keep in mind, the employees here, similar to what was done for PSI, right? I think we need to remember, what used to be here is the PSI seminar headquarters, which is my understanding, around October and September, they would have seminars with as much as 500 attendees. 500 attendees who would come in and out, who would use these facilities, who would stay there, who would eat their meals there. That is very similar to what is going on now, but on a much lesser scale. Very similarly, the employees who are at the Sowers Project, they stay there. There's a kitchen, there's a cook. They're not leaving to go and get lunch and things like that. There's actually a meal plan provided for them. They don't leave, they live there. They live on site. So they're not coming in and out every day. So it's really the attempting to say that everyone who lives there comes in and out and is going on breaks and is going on lunches and things like that is just not true. That is not what is happening. And these big trucks and things like that, there's nothing to show that these are actually connected to the Sowers project. They could be any other number of issues, any other number of other reasons why they're out there. This same area, where the cultivation area is now, I think it's important to remember, this is not virgin land. This was previously used. It was cultivated with sod. There's also cattle grazing done there. So it had been tilled before, and it was tilled again. And we'll get back to that. And I'll discuss that further. And I think it's also important to recognize that many of the comments, much of what we've seen today from Mr. Van Pelt and Richard, I cannot remember his last name, and also Mr. Johnson. These were generalized comments, policy recommendations, essentially. That it's not appropriate to grant an appeal of a use permit based on generalized comments and policy recommendations. That is something very, very different. As Mr. Johnson said, what he, and of course this is not the standard we're considering here today, but he says, well, if there's a substantial evidence of some type of adverse environmental impact, then there should have been an EIR. Well, substantial evidence is quite a high standard, actually. It's not the lowest standard, it's not the highest standard, but it's more, but it is, right, it requires an evidentiary standard of evidence. What is evidence? Evidence is not speculation. It's not conjecture. It's not incomplete hypotheticals. And that's basically what we have here. If this were to happen, then this might happen, and then you might have to find that. That's not evidence. So I'm going to get right into this allegation that there was some type of grading violation. I think there's been really a lot of misinformation surrounding this. Mr. Johnson and the appellants clearly have a misunderstanding of what occurred. It's not how it's been presented today at all. So what really happened? As we discussed, where the cultivation site had been previously tilled. It's our understanding you do not need a permit to till land. And that is what occurred here. However, first, what happened? The Department of Fish and Wildlife came out and did a survey to identify any streams or recourses or drainage or anything like that. They did not identify the drainage systems that are at issue within the cultivation area. They didn't identify them. They performed a survey, they didn't identify them because they had not been identified before. What happened was while there was tilling going on, one of the operators committed an error and went outside of the site plan. That resulted in a complaint. That resulted in the Department of Fish and Wildlife coming out and doing an inspection. And they said, well, yes, you deviated from the site plan, which was an accident, and it seems like someone else has identified that there may be some drainage within this cultivation area that was previously unidentified and unknown. And so that's what the remediation was about. The grading, it's my understanding, that's being complained of was remedial grading, not grading that took place illegally. This was remedial grading that they were ordered to do and had a permit to do. And I'm going to point out, because this has been framed as grading, which it is not, right? Grading has a legal definition. In Exhibit 18, I believe it is page 4, there's a receipt from the County of Lake regarding the grading permit. And in that, they say the tilling was done legally, but the contractor did not observe the course setbacks, right? There was an accident where they went outside of the site plan, and that's what they're speaking of. But for this accident, the tilling was done legally. So it's really a misnomer. It's really misleading to say there was illegal grading done. That's not what occurred. And why? Why did the Planning Commission, in light of this, decide to grant this project 4-0? It was not because of preferential treatment at all. It's because this was all before them. They had the letters from the county saying, nope, everything's fine, this was an accident, and the first thing that the Sowers Project did is they said, what can we do to fix this? What can we do to fix this? And that's what was asked, and that's what was done. And they entered into agreement with the Department of Fish and Wildlife, and now this was reviewed by the County of Lake. This has been reviewed by Department of Fish and Wildlife, and both said, signed off on it, say it's completely remediated, and we're good to go. Non-issue. That's what really happened. And which gets me back to the other point, right? Those two photos with large mounds of dirt, it makes it seem like something else happened. That's because those photos are not of this project. It's of somewhere completely else, somewhere completely different. We don't know where they're taken, but it's not of this property. And I would like to point out as well, as part of that remedial grading agreement with Department of Fish and Wildlife, there were built into that dust mitigation measures, which they did comply with. I mean, anytime any farmer does tilling or grading in the summertime, there's going to be some dust. unavoidable. It'd be the same if Brassfield was tilling its vineyards. It'd be the same if Monte Cristo on top of the hill was tilling its vineyards. There would be dust. But such dust would not be grounds for us to now say, okay, shut you down, you can no longer grow wine. That's not how it occurs. The mitigation measures were proposed by CDF, Department of Fish and Wildlife, and they were followed. So, it's really not true that this was in violation of the project description, because the project description does say that there would be this type of tilling and dirt disturbance to prepare the cultivation site, which was not grading. The early activation permit prohibits grading within the meaning of the code, which this was not, and that's shown that not even Lake County thought this was grading. They thought this was legal tilling, which occurred. So there, frankly, was no permit violation, or no deviation from the project description, which what had occurred, and that is why the Planning Commission, in light of this, approved this project. Next, speaking about the lights. We saw a photograph that apparently depicted lights. We're not sure when that photo was taken, who took it, what it actually shows. It could, for example, be the moon. It could be a headlight of a car on the road right next to where the person was standing. We don't know. But what did happen, in August, the applicant did rent a floodlight, and they had it for 48 hours. The first time they received a complaint from any neighbor about this, they immediately returned it to the company they rented it from. They rented this floodlight because it was about 100 degrees during the day, and they had to get a project done in the evening when it wasn't so hot. This is the same exact thing that every single winery in this county does. Every single vineyard in this county in August, when they're working, if you get up very early in the morning like I do, and are driving to work, you see people out in there working with these lights. It's because it's too hot. It's too hot in the day, and actually OSHA prohibits people from working, as my understanding, in heat above 95 degrees. So this was actually an employee safety issue, and as soon as there was any type of complaint or anything, it was taken down less than 48 minutes, and it is our position these were shielded down, and they were not being done for cultivation purposes or to manipulate light or something like that. It was to get a project done. It's our understanding as well that there hasn't been another complaint about light such as this. That was the only one, and it relates back to August. The other complaints about light seem to be from the existing lights that were there when PSI was running the place. No other lights have been installed at all. All the lights were existing lights from PSI. And this is quite a large campus. PSI had a lot of lights, right? They had their driveway lit up coming up to the campus, and they had other lights around. Now, I know there was a comment about a flashing yellow light. Well, that's the security patrol, which they're required to have. I'm sure if there's some issue with that particular light, we could talk about that and have the security patrol remove that light. But really, this is not what it's made out to seem, that they are, for example, using mixed light grow or something. That is not what's happening at all. And I'm going to get to the hoop houses in a minute too. That's not what was occurring in the hoop houses at all. There was no light for growing purposes to say, and every type of light there is for people just to see where they're walking. There's also been a lot of discussion about this Brassfield pipe. Now, there was that YouTube video. I know that was actually posted to YouTube. I'm not sure if that was the entire thing that was posted to YouTube or not. But what this does show, it's not an underground pipe. It's actually above ground. And if we did follow it all the way to the end, you would see where it hooks in. It's not the same system. It looks to be the same system, but it has a separate valve. So these are actually separated, and they're not used at the same time. They go to different places. One was for the sunflowers. The entire other system, in which is subject to the the initial study, was for cannabis cultivation. These are really separate, very separate issues. However, in spite of that, it's my understanding that pipe is completely removed. It is no longer there. It is not being used. They're just not going to have sunflowers anymore. That's what's going to happen. So this pipe was not necessary for cannabis cultivation purposes, and it was not used for that, ever. And that's shown by the fact that it was actually removed, right, without touching any of the other irrigation systems. This one was removed. The pipes were returned to where they were rented from, and that's it. So also about dust and odor. I know that the appellants, they had some comments that this isn't in the initial study. That's not true again. There's actually significant sections regarding dust and mitigation members as well as odor and what the applicant has done to mitigate those. Part of that you're going to see in a minute. The setbacks of the cultivation site from any residence far exceeds what is required. It's my understanding it's between 1/4 and 1/2 mile. Far exceeds. And they've done that to mitigate odors, to be good neighbors, and I might add, at an exceptional cost to them. They didn't have to do these things, but they've done these things because this is what they thought would make it a better place for their neighbors to live. Specifically, dust is mentioned. Dust and the mitigation members are mentioned in section 3 under air quality, and there's quite an extensive analysis including mitigation measures. Section 10, hydrology and water quality, also discusses dust. So it's actually analyzed quite significantly, and there's no, despite these photographs taken out of context, there's really no evidence that there's been the kind of dust that would constitute a significant environmental impact. And that is what we need to keep in mind. Is this a significant environmental impact in relation to, right, the surrounding areas, what they've been used for? And like I said, this is an agricultural area. And everyone agreed with me on that. So I'm going to talk about these hoop houses now, because I know that and this was our first time hearing that planning, they are recommending that there be some remediation of this before there's I suppose a decision on whether or not to approve the use permit. So let's talk about that. The emails and excerpts included in appellant's presentation are extremely misleading again. They're cherry-picked and they're not representative of what actually occurred. And that is really a theme throughout their entire presentation. That is a theme throughout everything they've done here today, really. Submitting late documents, not giving us a chance to review them, mentioning other documents that I'm not sure if they're on the agenda or not. They seemingly were emailed to the board this morning, and they expect us all to be familiar with them. So what actually happened? Applicant had an early activation. So, right, cannabis, you're allowed to grow cannabis in California. You're allowed to grow cannabis with an early activation. They had that. It was valid. They grew cannabis. Now, what do you do when you're done growing cannabis? You have to dry it. If you do not dry it, it will rot. If you do not dry it, it will all go to waste. It's really illogical to take the position that you can legally grow cannabis, but you cannot dry cannabis. You can pay millions of dollars in excise taxes on the cannabis you grew, but you have to throw it away when you're done. That is an illogical result. And this is why, on 3 separate occasions, the applicant touched base with planning in writing, saying, what can we do? Is this authorized? Is this not authorized? What are the guidelines on this? It is not true that they got a response saying you're not allowed to do this. That is not true. What really happened was the indications they returned was, we're not sure. There's no law on this right now. This is kind of a gray area. We're not sure. There's some precedent. We received a copy of a memo and an email indicating there's actually some precedent to allow hoop houses. There may actually be precedent for this, but we're not sure. There was no response at all. And it's our position that this was not construction. These were not structures. And of course, the appellant is entitled to appeal this this notice of violation. It's our position this is not a violation, this is not a citation. It does not actually become effective until expiration of the 30-day or the appeal period. So they still have the ability to appeal this, which runs 21 days after the date of the notice, which was November 10th. So we are still in that window. It has not expired. And also, the notice itself says, well, if you remove these temporary, what I call temporary accessories, then there will be no violation. And that's what the plan is. I can confirm that as of last night, already 6 have been removed, and the ground, consistent with the early activation conditions, has been restored to its original condition. We'll have a photograph of that so you can see what it looks like. So there was no construction that took place. There were no machines or no excavation used at all. Everything was done by hand. They did secure the posts of these, it was basically large tents into the ground so that they wouldn't move or blow away. And as far as the applicant was aware, that this was not prohibited under the current regulations, because we could not find anywhere saying that it was. Planning was not able to show us somewhere where it said it was. And it sounds like this is continuing to actually be an open issue as far as planning is concerned. And now as far as structures, planning, they said themselves that structures within the definition and construction within the definition constitutes some permanency. I believe that it was 180 days or more was the time frame reference. Well, these are anything but permanent. These were intended to be temporary. They're put up on an extremely emergency basis, and they're being taken down already. Within the following day after receiving the notice, they started taking them down, the following day. And they're continuing to do so now. And I would just like to reiterate as well, there was no growing occurring inside of these. So there was no lights being used to grow inside of these, no growing of anything whatsoever occurred inside of these hoop houses, which I will call. Now about the generators, because that seemed to have been what actually caused the issue. I want to point out again, this notice in violation, and it is actually included, I believe, within, I'm not seeing it on here now, but I think it's attached and made available to you, but the notice in violation was made to Aviona LLC, the property owner. This was not a violation on the permit. This was not a violation related to cannabis. This was an alleged building code violation related to electrical systems. I'd like to discuss those electrical systems. First of all, there were no plumbing systems at all in there. I'm not sure where the appellant got that information. They just didn't exist. But, so how are these powered? There was 2 diesel generators, 2 of them, and they had what's called a distribution box and a spider box. These diesel generators, and you saw pictures of them, they're approved by the state of California for use without a permit. That's what these are meant to be. You don't need an electrician to install these types of generators. You don't need a permit to use these types of generators. They're actually made to be done without that. And same with these types of distribution and spider boxes. They're essentially self-contained units made to be user-friendly in a safe way for this exact type of purpose, or you'll see people use them when they have concerts outside, things like this. They're made to be used by people, not electricians. So that's really what was occurring there. And as I said, they've already been taken down. There was no type of hardwiring into PG&E or nothing like that. That's not what occurred at all. And now, I would like to point out as well that the management plan and the initial study, they all discuss the use of generators. The appellant had a lot of slides saying how this was never discussed. That's just plainly not true. They said throughout both documents, in case of emergency, we may need to use generators. And I believe that's consistent with every single cannabis cultivation project in this county, nearly. In case of emergency, we may need to use a generator. And the EA conditions of approval say that's okay, so long as any diesel equipment is California compliant, which these were. So it's our position there was no violation of early activation. They were not cited for a violation of early activation. They were cited for an alleged violation of a building code, which is still, quite frankly, an open question. And due process has not played out on that matter yet. I'd also like to point out in the initial study, section 6A, as far as energy. So it does say, and it says right in there, that would use diesel generators to provide power in emergency. So that was analyzed actually in the initial study. It's included within it. Again, in section 9A, hazards and hazardous materials, says we'll use generators. Again, in section 8A, under noise, it says again, it says we'll use portable generators. And the noise from these portable generators may reach high levels. It says it right in the initial study. In the same section, when discussing dry storage, which is what these were, right, quite frankly, if the entire project was presupposed, had it not been pushed out and continued, they would have been able to construct dry storage. And that's what this project proposed, construct dry storage in this exact same spot in a very similar way. However, because of the appeal and then the continuance, they were not able to do that. So they were left with a very, very tough decision, and they, like I said, asked guidance about this. Do we let our entire investment in crop go to waste, or do we can put up these temporary agricultural accessory buildings, which we think are actually allowed, and no one's told us they're not, to save it? And that's what was done. They received a notice that, hey, we don't think you're allowed to do this. The following day, they started taking them down. And I think that's one of the main points. This was not the regular operation that this occurred. This was an emergency. This is, right, this is something that was not really intended to happen, but was done in a case of emergency. And the initial study does contemplate for emergencies. Some additional aspects about water, because I know that is a huge concern in Lake County. It's a valid concern in Lake County. However, water has been extensively studied in the High Valley Basin. It has been extensively studied specifically with respect to this project. Now, in reviewing the appellant's information, I know that they included a letter from Angie Dodd, a purported expert. It's my understanding Ms. Dodd has been, right, again, revealed through the Public Records Act request. Ms. Dodd has been raising some of these issues for a very, very, very long time. First, it was behalf of RX, however. It is now on behalf of appellant. It's changed. However, the concerns are illegitimate. Her critique of the hydrogeology report itself is faulty. I'm just going to point something out. She makes a big deal in that about a graph that shows some type of well monitoring. But when you really look at what the graph shows, it shows the trending line, and the aquifer base level is trending upwards, according to her own graph. But really, that graph and the well monitoring data from it is really irrelevant. We're not sure what it's showing. Who knows what instrument was being used since 1960 to monitor this? What is relevant, however, is that Kimley Horn came out with qualified hydrogeologists and did a drawdown test on these exact wells in relation to this specific project, and came up with a report about it, with hard data and facts about it, and determined there's more than enough water to not just support this project, but the other projects occurring as well. So in closing, it's really our position that the appeal should be denied. However, in light of all of this new evidence that has only come to our knowledge today, in light of the fact that there has been photographs of other properties presented before the Board of Supervisors today with claims that they are actually the Sowers project when they are not, in light of the fact that there's been videos and photographs of other alleged incidences which we have no way to verify. We don't know when these allegations occurred. We don't know who witnessed them or anything of the sort. We've really had no opportunity to review Angie Dodd's or the other purported experts' materials. We really haven't had an opportunity to review these hundreds of pages that were placed in front of all of us last night. It's our position that it would really be improper to consider any of it, in addition to the issue with the hoop houses, which is anything but resolved. As we said, I think we have strong positions to say why it was not, in fact, a violation. It's our position that if that material were to be considered, then this matter should be continued to a later date so that we have an opportunity to address them, so that we have an opportunity to point out the wrong evidence that is being presented here today. So we really have an opportunity to address that. And that's the same thing, quite frankly, the appellant had asked for last time we were here. They asked for a continuance so they could review the evidence. If the supervisor intend to consider this new information, we will ask for the same thing today. But irrespective of that, there is no direct evidence of significant environmental impacts. There is no actual evidence of violations the way that they've made them seem. That's not what occurred. In fact, it's quite the opposite. Everything has been done. The initial study is extremely lengthy. There's a lot of mitigation measures involved. And I would like to point out the code complaints that were attached with the letter. I believe they're around 25 pages. All 25 pages are from two people. One is a repetitive code comment from a woman named Miss Kahn. The other is from the Bradley firm. Those are the only two. So with that, I respectfully request that the appeal is denied. However, if the board were to consider this new information, we would request for continuance on that basis. Thank you very much. And Mr. Armstrong now will have a PowerPoint presentation will help show some photographs regarding a lot of what I've said today. Thank you.
I'm not exactly sure where the PowerPoint went here.
Looks like Sam's coming to save you. Thank you, Sam. And then let's wait for him to shut off the lights, and then we'll get started.
Yeah, okay, great. Okay.
Thank you. All right, good afternoon, supervisors. Good afternoon, county staff, and everybody else in attendance. Without further ado, I'm just going to jump in here and try to address some of the issues that we've already been over. So the appellant mentions some grading violations, earth movement, dust.
I'm sorry to interrupt. In case I missed it, I'm just being reminded by my colleague. Can you make sure we get your name?
Sure. My name is Tom Armstrong.
Okay, thank you.
And we're going to hop right in here with the addressing of the grading issues. It's important to provide a little context here. As you may or may not know, any applicant, both from at the county level as well as at the state level, must submit documents, to the county as well as all applicable state agencies. The Sowers team did so. We submitted the required documents to CDFW. They did multiple desktop reviews, not only during their initial investigation, at which time they issued a lake and stream bed alteration agreement, but they also came out and did an on-site inspection prior to the issuance of that lake and stream bed alteration agreement. Third point, we had a biologist come. They identified what they felt were the appropriate water courses there. We submitted all this documentation, as I say, to both the county and the state agencies, including CDFW. We were issued a lake and stream bed alteration following these desktop reviews and the in-person inspection of not only CDFW, but of the county as well. We proceeded, once we were alerted that we proceeded to do some disking to prepare the land for cultivation. In doing so, one of the neighbors complained, and CDFW came back out. It was only at that time did CDFW then identify that there was some potential drainages there. They were more than willing to work with us, as were we willing to work with them. We were extremely proactive in working not only with CDFW, as well as the county. In doing so, we were issued a new lake and streambed alteration agreement. And just to touch on it here, you can see the senior environmental scientist supervisor, Kirsten Sheridan, authored this letter to the Planning Commission and to county staff, and I'll just read it here for you, a brief synopsis here. CDFW is confident that Tom and the Sowers Farms Group are committed to remediating the issues brought forward and have already shown considerable effort in fulfilling their obligations. We do not have any objection to their project and look forward to working with Tom and his team on future cultivation projects. Once again, any grading issue that potentially happened was something that was brought up to CDFW, was brought up to county staff, and was immediately remedied and taken care of.
What's the date of that letter?
This was prior to the second hearing. I don't have the exact date off the top of my head. I want to say it was in July, mid-July. Like I say, prior to the Planning Commission hearing where it was unanimously approved. I want to bring up too the dust mitigation measures. There was claims by the appellant and Mr. Johnson that there was no dust mitigation measures. That's patently false. We've submitted numerous receipts to county staff demonstrating this. As well as you can see, the picture on the right is a direct picture of the property, the installation of straw wattle. It shows the soil compaction. We use an organic dust suppression treatment to try to alleviate the dust. We also used a water truck, which, as I say, we submitted multiple receipts to Mrs. Schaefer's and county staff demonstrating this. And as you can see, as I say on the picture on the right, you can see the soil compaction, the installation of the straw wattle. I want to point out the proximity to the neighbors, the appellant, and the distance from the property line. I think this is important to point out given the considerations as it relates to noise, odor, dust, and the like. Per Article 27, the minimum setback for an 8 Type 3 license is as follows: 100 feet from the property line and 200 feet from off-site residents. This is important to point out because when the legislation was carefully crafted, they put these setbacks in mind to purposely make sure that things such as odor, noise, and dust were at an appropriate distance from any other neighbors. And as such, they came up with 100 feet from the property line and 200 feet from the off-site residents. As you can see here, from the picture depicted on the left, the distance from the property line to the nearest grow location is nearly a half a mile. If you see on the picture on the right, the distance from the nearest drying area to the property line is a quarter mile. Obviously, as you can tell, that well exceeds any of the thresholds that were put in place under Article 27. And I would mention, we purposely amended our project, as Mr. McDonald just mentioned, to appease the appellant's concerns, to appease neighbors, and to try to do as best we could to be, as good neighbors and as accommodating to their concerns as possible. I want to bring up the concern of odor. I know Mr. Johnson mentioned this a lot and mentioned about how AQMD might, be interested in doing this. And as a matter of fact, the board, you might remember in 2019, actually had this in front of the board, and they voted to halt the expansive air quality inspection program. And as Supervisor Simon, as you pointed out at the time, pending federal legislation, odor from this crop would be exempt from any regulation. So I think that's a brilliant point you bring up, and I just wanted to make that known here. I want to point out a couple of things here. Noise levels, as you're well aware and of what we discussed thus far, the noise level at the property line is supposed to be 55 decibels throughout the day. The appellant showed some readings. None of them were videos. They were just a picture that could have been taken anywhere. We don't know where it was taken, when it was taken, the context in which it was taken, if someone was speaking. As you may or may not be aware, if you're staying there reading the decibel level and someone speaks, that can significantly change the reading of the decibels. Here, as you can see, 2 of these are videos, which we'll play for you here shortly. The one on the furthest right is just a picture, and that's taken about 100 feet interior from our property line, pretty close to the appellant's property. And as you can see, the decibel reading there, it's a little hard to see given the lighting in the room, but it's reading at 37 decibels, which is similar to a quiet library. And this was at the time that fans were running, I would point out. I'm going to try to attempt to play this video here. I'll play the first one. As I say, this is about 100 feet interior from our property line and adjacent to the appellant's property line. If you can hear anything, the only discernible noise maybe is some wildlife that you can hear in the background, birds chirping and things of that nature. Also, as you can see, we took videos. We didn't purely take pictures because a picture doesn't do much. You can show us a picture of a reading of 60-some decibels or 70-some decibels. Where was that picture taken? There's no context to any of those pictures that we saw previously. I also have one here in the evening because I know that in some of the comments they mentioned that the sound was a little bit more disturbing in the evening and versus during the day. And you'll see here that the highest reading here is 36 decibels, which as you can see over there is equivalent to a quiet library. And we'll show you this video here as well. I'm going to try to raise the volume here. I'm not sure. Let's see. Is there any way to amplify the volume by chance?
I think the only place that the volume is going to is probably on Zoom.
Okay. Well, I think it's important to point out here, right? A couple things. One, as it relates to light, you can barely even see me. I'm in this picture. This is a live footage. You can't see any lights, so I'm not sure. In terms of lighting, it's not an ongoing issue. As you can see, you can barely see me, let alone any lights in the background. As you see here, it ends at 32 decibels. I think we've talked a little bit about the noise here. Let's see if we can pause this. Lighting concerns. This is another video that kind of outlines. That's a neighbor, by the way. This is one of our closest neighbors. Those are the lights. You can see this is the property line here on High Valley Road. We have this white fence that borders pretty much all High Valley Road where we have the property. As you can see, it's pretty hard to see anything at all. I'm barely visible in the video. But yes, as it relates to lighting, this is the lighting that you see from High Valley Road. I'm not going to bore you with the rest of the video. You can't really hear it, but you get the picture. Obviously, water usage and localized hydrology is an important matter for not only for us as the applicant. I mean, of course, water is a limiting factor. If there's not water there, we don't have the ability to grow or can't be a viable company. It's an important point to make. So prior to embarking on this project and prior to going in front of the Planning Commission, we did hydrology studies and we did hydrology reports, as it's important for us, as I say, as a business. As you can see here, I'm not going to hash on all the points here, but you can see the annual recharge is estimated at 2,300 acre feet. And our project, at a very max, the 353 acre feet is an extreme conservative number that's very well over what we ended up even using this year and what we would use annually. But even if you use that number, that only represents 15% of the annual recharge. And if you look at the cumulative impact area, which is articulated in this picture below, the cumulative impact area between Sowers HVR and Brassfield Estates Winery cumulatively, own 56% of the cumulative impact area, and this project is only using 15%. And mind you, as I say, the 353 acre feet is a gross over-exaggeration of what we use. We did that as a safety measure for not only us, but just to demonstrate to you all that, look, even if we tripled our water usage, we're still only at 15% of the annual, using 15% of the annual recharge, whereas cumulatively between us and Brassfield, we own 56% of the land in the impact area. I want to do a little aquifer illustration here so that you can get an idea of the aquifer and where we're drawing water from. As you see, there's three different labels here. There's A, B, and C. C would represent the deeper aquifer, which is where we're drawing water from. And A is where most of the residents are drawing for domestic wells. And I point that out because I know in some complaints, some people have maybe mentioned that, oh, their well was an issue. But I would also point out, which you'll see in this next slide, or not this slide, but the following slide, we'll come back to this. Here, we were actually submitted an unsolicited email by one of our neighbors, and actually they CC'd the appellant on this email. And you'll notice that this neighbor had been monitoring his well, and I quote, "I've been monitoring my 2 wells weekly for over a month, and I find absolutely no change. One well goes down 1.5 feet while pumping, but then recovers to its original time level later. The other well has exactly the same pumping level as the static level. These levels have not changed since I've been started measuring." And end quote. We're going to go back to some water conservation measures here. I wanted to bring this up because to reiterate, water is important. Not only is it important for us, it's important for the neighbors, for the local community, and the viability of not only the operation, but the land. As such, we've implemented various water conservation measures, including drip lines, tensiometers to measure the amount of water in the soil and how much water we're using, as well as the installation of plastic mulch. These are all things that we've done to proactively ensure that we're being as efficient and as effective of our water usage as possible. I'd like to point out here the newly enacted Ordinance number 3106. You'll notice here that as a result of the records request, in correspondence from Ms. Schaefer's to Laura Hall and Susan Parker regarding the implementation of the Ordinance 3106, and I quote, "Ordinance 3106 was created based on the water use analysis of UP 21-10, which was more thorough and more in-depth compared to any cannabis projects that have come before the Planning Commission." And this was the longest-standing commissioner, Commissioner Hess. Mr. Hess then requested that the Board of Supervisors to provide official guidance. The guidance became Ordinance 3106. This is important to point out because as the appellant and his representation have made the assertion that there wasn't thorough environmental analysis, that seems patently false, especially given light of some of this information here. I already touched on the water availability and how this is tangible evidence right here from a neighbor that had been monitoring his wells, showing no effect on his wells, right? I know the appellant also made note that the word drought wasn't included in any of our documents, and I think that that's a little bit of an over-exaggeration. Drought is a recurring feature of the California climate. Any of the stuff that we've done, any of the documents we've presented, inherently include the assumption that drought would be occurring. And you also notice too that the EBA report that we provided as well was developed in 2016. 2016, as you all are aware, was also a significant drought. So these factors were taken in consideration despite the fact that drought was not mentioned. And the appellant also called to question some of the qualifications of our preparer. I want to point out Mr. Sammy Corder, he's a PE licensed in the state of California. We also had Jason Sheasley. They both worked in tandem on this project and are both experienced groundwater experts. Another issue that's obviously come to light and that's been a big topic of conversation so far this morning and afternoon has been the inclusion of the Brassfield Pipeline. At the request of county, the Department of Cannabis Control came out. They did a thorough inspection, and you'll notice, it's hard to see here, but we were in compliance in every aspect of the report. Not only that, but they verified the water source that we were using and verified that the Brassfield water source was in fact not being used for cannabis and was in fact being used for sunflowers and to water the livestock, as we articulated. And as such, I think Mr. McDonald mentioned, because of all the trouble that this pipeline has caused, we've even gone as far as to remove it altogether. Biology, there's been a lot of issue made about our biological studies. I would point out we did have in-season biological surveys to delineate flora and fauna. And actually we had two, as you can see here, that's articulated in the first sentence of the second paragraph. For potential to occur of specific status, special status wildlife, we similarly found habitat requirements lacking on the proposed project site with the exception of 2 special status bats. Mind you, during the Planning Commission hearing, especially the second one, we articulated how not only did we amend our project to reflect the boundaries that we had after having those surveys from the bats, we took into consideration those bats, and like I said, we amended our project, and we didn't do site preparation in those areas where the bats were found to be until they had fledged the nest. Security. The appellant mentions that security is the big issue for not only the community, but obviously for us as well, right? We don't want anything that's going to damage our product, our employees, and the local community. We care about where we're operating, we care about our neighbors, and we care about ensuring the viability of our business. As such, we've contracted with the licensed security firm David Shield Security. We have ample security there on site that are trained, licensed security professionals that ensure the safety, protection, and security of not only our crop but also our employees and the community around. The appellant makes some assertions about noncompliance with the zoning ordinance. Specifically, the preparation of materials was by the applicant's team. As Ms. Schaefer has correctly pointed out earlier, this is standard procedure. If you're applying for an application, you typically would have to prepare the materials for the county to review. The county did do a thorough analysis and came to the conclusion, and hence why the Planning Commission voted to approve the project unanimously. I'll point out here, you'll see a couple of the commissioners' glowing remarks as it in regards to the project. Commissioner Chavez stated, compared to other projects we've seen, they've put in a lot of work and continue to go far and beyond to make sure neighbors and public concerns are addressed. You also see Commissioner Hess here, and he stated, I'm the last standing commissioner who was part of writing the cannabis ordinance, and I've been present from the very first vote on the very first application, and I've seen lots of applications, large and small, and this is truly, in terms of my review, one of the most comprehensive and carefully crafted applications that I've seen. I want to speak to cultural resources for a minute. The appellant made the case that there should be tribal monitoring. Not only did we have the AB 52 consultation, we sent out 3 requests to tribes and had no response whatsoever as it results to that. We had here a archaeological study done by one of the foremost experts in Lake County archaeological history, Dr. John Parker. As you'll see, he identified a couple artifacts here, and identified a buffer zone that was appropriate to ensure that we did not encroach upon any of them. We more than adhered to this buffer zone and weren't even in this area. As a matter of fact, between the first Planning Commission hearing and the second Planning Commission hearing, we had Commissioner Batsulwin Brown out to the site. He did a site visit and ended up, giving his blessing and saying that the cultural resources were not to be affected there, and actually voted for approval of the project. I'd like to point out traffic. I think one of the important things to point here is that typically when you're assessing traffic, you do it as it relates to the previous use of the property. The previous use of the property had more average vehicle trips annually. It's also important to note that irrespective of the employees that we have, 99% of them live on site. These are not people that are coming to and from work every day as maybe you or I might. These are people that live on site. And as it relates to, I do want to point out too, as it relates to traffic and the mention, I know the appellant and representation made the assertion that this wasn't addressed and that housing wasn't addressed. We specifically, it was addressed and was mentioned. As some of you may or may not know, PSI Seminars was actually intending a hotel at that site, and as such developed plans and included a septic system to purposely be able to support large volumes of people. Additionally, there was existing 120-bed service there at the site that we inherited when we purchased the property. I would like to point out that we did pay the county grading fine, received the grading violation clearance, and you'll see that those were all paid. Furthermore, we did also pay the CDF remediation fees. Those totaled over $16,000, which we expeditiously paid as we were issued the new lake and streambed alteration agreement. To touch on the hoop houses, as you can see here, this is a recent picture that was taken yesterday afternoon. 6 of the hoop houses are already taken down. As you can see, there's no excavation that was done. It was done all on the surface of the ground. There was no excavation or cut and fill that was done there. These are not permanent and not construction, and the land was restored to its previous use. These are temporary tents, as Mr. McDonald explained, and they're in the process of being taken out as we speak. I'll leave you this with the conclusion. These are two of the remarks which you've heard me speak about a little earlier, but it's something that maybe you can marinate on. And after the two long Planning Commission hearings and all of the materials and information the Planning Commission reviewed, had the opportunity to analyze and mull over, they came to some of these conclusions, and I'll leave you with that.
Thank you for everybody's presentation. Thank you for turning on the lights. If we can stop the share on Zoom so that we can see everybody.
I believe we do have our consultant on.
Yeah, I would point out too, we do have our hydrologist on the Zoom as well, so if there's a need to hear from him, he's more than willing to, right.
I'm going to ask the board, would you mind to just have that person on deck if there's questions about the hydrology, since we've had a long day of presentations thus far, or would you rather hear from them right now? Okay. Well, if there are questions specific, we'll go ahead and ask them to respond.
Excuse me, Mr. Chair, so perhaps then they could point to where the hydrologist report appears in the record, so your board will have the opportunity to review that again, since it's de novo and one of the findings you'd have to make for a use permit.
Exhibit 12, if I'm not mistaken, original water analysis hydrology.
So Exhibit 12 does have the original, and I believe, and I'm going to look at the planner, Catherine Shavers. I believe it also has the update to it as well. I think it starts with the update and ends with the original, if I remember going through it correctly. Right, and I think if you keep going down, then eventually you get the original form as well.
We also have
If please go ahead and finish what you're saying, but do it on the microphone, please.
We also have, I think it's turned off. Oh, no, we also have Brad Stoneman on deck who can speak regarding the traffic analysis as well.
Okay. I just want to check in all the people. To be honest, I was focused on the board chambers. All the people that were planning to speak today in the Zoom room, I was not paying very good attention. If you're going to speak and you have not been sworn in, you need to let us know, because we need to do another swearing in. So Supervisor Crandall, I see your hand up. If you could put your hand down for now. I'm going to ask everybody who is in the Zoom room, or everybody who may have just come to the boardroom who has not been sworn in, right now would be the good time to raise your hand and let us know, so we can make sure you get sworn in, so then we can go ahead and move forward with our discussion, and then afterwards with some public testimony as well. And I see a couple of hands up in the Zoom room, none here. And so, Johanna, if we can go ahead and do that again, and if we can unmute the two folks with their hands up so we can make sure and hear their I do's.
Okay. With your right hand raised, do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do. Thank you.
I do.
Okay, we had 3 people, and I heard 3 responses. Thank you very much. Let's go ahead and remute them. And Supervisor Crandall, let's go ahead. You had your hand up.
Yeah, I just wanted to, if it's possible that I could share my screen just to highlight and be transparent about the document that was brought forward, which I'm glad that there's transparency, and I just want to highlight something about that if that's possible.
Okay, if he's not able to share, if we can make that happen, please.
Supervisor Crandall, you should be able to share your screen.
Okay, so I'm just highlighting. If you can see can you see my screen?
Yes.
Okay, I'm just highlighting that this came to me Friday, September 17th, 2021 from Tom Armstrong. And it was a CC. As you can see my name right here, it's a CC. So I didn't respond to it. I didn't call anybody. And then Tom called me, and so I forwarded it to Carol on the 22nd, which is a Wednesday. This was a Friday. So that email came after as like a forward and a summary to Carol, because I realized afterwards that Susan was out of the office that week. And she too said, I got this too last week. And she asked the planner assigned to this matter to respond to Tom. That's when I dropped it. That's when it was done. So just highlighting that that was a summary. And I just want to ensure that this communication is transparent and that everything is highlighted there. So yeah, I just wanted to highlight that. Thank you.
Thank you very much. Looking for any comments or questions from board members on everything that we've digested over the course of the last 3 to 4 hours. So I'll get started. There are definitely some issues that I've seen in reading all of the documentation. I feel like there is a way to make this project possible, maybe not as it is described today in front of us, but I also have some issues in the way that it's been brought to us today. And I think I need to just express that, but also put that to the side. I know that similar to Supervisor Crandall, my name has been brought up. One of the things was about the issue of the public noticing, which is very strange. I was very misread. I created a resolution because I felt it was unfair to the public to not get public notification. Granted, I did not request in the resolution, nor was it approved by the board that it would be specific to the neighbors. It would be a public noticing to the entire county that these projects were happening. I think even 1 acre next to you should not pop up in a surprise early activation, which is what we were seeing at that moment in time from our community development department. And I think that we have to recognize there is a nuisance that comes along with cannabis. It is not a smell-free plant. And I think that it's only fair for the community to know and understand what is coming in their area and in their region. At that point, staff had taken it to the next level of making sure it was specifically submitted to neighbors, and that is the CEQA guidelines, similar to what is followed when the use permit process is being completed. And so I expressed myself and am not correct in the sense that they are that they were taking it to an extreme measure. No, they were actually following CEQA exactly as it was. And I have learned more about CEQA and continue to learn more about CEQA because CEQA is a complex process where it's not necessarily a matter of what is right or wrong. It's a matter of balancing the request of an applicant and the needs of a community. And I think that one of the things that I struggle with, and certain things I'm just going to somewhat throw out, it's difficult because we are aiming for trying to move out into more open space, into larger properties, more secluded away from what would be our community growth boundaries. It's more secluded, more peaceful environment for some, but when it's on agricultural land, we also can't necessarily change what agricultural land is made for. And we have to be careful, and again, it's a balancing act of saying you can't when it's when you look around, there's ag preserve in that area, there's agriculture in the area, and even rural land and rural residential allows for agriculture to be done when you look at the use permits without even a use permit. It says an allowable use is agriculture. If you want to do lavender, if you want to do other stuff, my guess, and I'll look to CDD to correct me, is I don't believe that there is a major use permit or minor use permit required, depending on maybe how large the field will be. And that can have a nuisance as well. Not everybody loves lavender. I love the smell of lavender, but that doesn't mean that it's not a potential nuisance. And I think that is one of my struggles for that area of High Valley, is neighbors should not necessarily change what High Valley could be, but at the same time, a new business coming in shouldn't necessarily completely change the comfort of those who are in High Valley. Again, balancing act. There's two problems. Well, one, I guess maybe I should start out with more with questions to staff. There has been some discussion about grading. There was shown some proof that there was a grading violation and that it was taken care of. Is that grading violation based solely on what CDFW brought to our attention, or is it based on the tilling that occurred as well?
Is this on? Okay.
Almost.
Okay.
You got to try it twice and then it's on.
Sorry. Yes. So the grading violations that were talked about today, under the early activation permit, no grading is allowed. So what the applicant performed was an activity that went too close to some riparian corridors and waterways. And that boundary is what the grading violations were about. So the violations with the CDFW, with those boundaries, the closeness, is what triggered the grading violations with Lake County. What was mentioned before about the tilling, that was an allowed use that we allowed them to do under the early activation permit. That wasn't something that was considered grading at the time.
And is that for the fact that it's been grazing land or pre-disturbed
Yes.
prior to that?
Yes,
Okay.
based on that, yes.
Okay. I have a question about the dust. There definitely were complaints about the dust, and also there was complaints about 24 hours of work. And I will say that I do have a certain level of frustration that, yes, there was a small time frame for the applicant to get things done, but I feel like there may have been a crossing of the line, and I need you to help me out to know the dust, was that reviewed? Did it cross a line of, yes, there should have been better measures? Because I did see some pictures, and to me it looked like those pictures were from High Valley and of the property. And so I have a question on that from the perspective of CDD. What was the position?
Sure. May I start by pointing out one of the exhibits? It's the early activation conditions. This is going to be Exhibit 20. I'm not sure how to get this on the screen, though.
And so that's the early activations conditions of
Yes.
approval that you're speaking of?
Correct, yes. Is there a way for us to connect to Granicus? It's on Granicus. It's Exhibit 20.
Here, I'm going to help you out with that, and I'm just going to share my screen. That way I think that will just simplify the process.
Thank you.
What am I sharing? There it is. And let's see if we can make this a little bigger. That's not working out. Okay.
So if we scroll down, we have early activation conditions that prohibit grading, but also have boundaries about when noise levels and work can be performed.
Okay, so that's the non-construction part?
It's towards the bottom, I believe.
Yeah, I believe there's a non-construction hours or something along those time. Maximum non-construction related sound levels shall not exceed, I have to move
55 decibels, yeah.
55 decibels between the hours of 7 a.m. and 10 p.m. and 10 p.m. to 7 a.m. within residential areas as specified with zoning ordinance section 21-411112. I will say that I was slightly confused by that. Is there supposed to be a different decibel level between 10 p.m. and 7 a.m.? Because it looks like it's a 24-hour thing of 55.
That's not specified in our zoning ordinance.
Okay, okay. So it does use both time frames, but it is 55 for both. Okay.
So we have another section here that's about dust. If we can maybe scroll down.
Is it lower or higher?
I believe it might be higher, but I could be wrong.
Here, let me see if I can do this. No, it doesn't look like it is a searchable thing. Production well, hazardous waste. No grading. A dust mitigation plan may be required should the applicant fail to maintain adequate dust controls. Is that the part you're looking for?
Yes.
So right here at the bottom of page 2?
Yes. So this condition is meant if the dust becomes kind of a bigger issue. So we had complaints that came into the Community Development Department about dust. For a summary of this, as a planner, I don't really have a summary of how the issues were handled. This came into our Code Enforcement Division. So I think I would defer at this point to my colleagues for those that would have handled that at that time.
Okay.
Same work. I don't think it's.
You got to try it twice. Eventually, Sam will get you.
So, I don't, okay. So I'm not privy to anything that happened a week prior to October 22nd, 2021. I was not involved in this. Only that prior week that I was aware that complaints had come in, and then I was assigned to look into the matter. I have no knowledge of what occurred prior. I do believe our former code enforcement manager, Andy Williams, had taken this project under his wing, and he looked into it. I have no knowledge of his findings. I have no information in our databases. There's no documentation, so unfortunately I'm unable to comment on this time as to any dust issues. When I was involved, I did not observe any dust issues.
Okay. And so again, reviewing the hours that we just discussed, there would be nothing within the EA approval to prohibit somebody from doing not grading work, but tilling work in the middle of the night, as long as it doesn't exceed 55 decibels.
If we're going from what is written in the EA, that's correct.
And I believe conditions of approval is somewhat the guiding force for anybody who has a permit under early activation, correct?
Correct.
Right. Okay. I have a question about the sunflowers. Who is the one who made the decision? Was that CDFW in coordination with CDD to make a decision that it was not part of the project, therefore not part of CEQA, or were the sunflowers added towards the latter part of the project process in order to, as was stated earlier, to appease the neighbors? Just kind of curious about how that was decided that it could be separate.
Sure. So between the July 8th Planning Commission meeting and the 22nd, the video and images of the Brassfield Pipeline came into the CDD. This was not something that was part of the project description, therefore it was not analyzed in the initial study. So during the July 22nd Planning Commission meeting, the applicant had been asked to prepare a few statements for Planning Commission's review, and staff had also asked the applicant to explain the Brassfield Pipeline and also the sunflowers and the water. So the applicant's consultant, Kimley Horn, prepared a statement. Staff reviewed that, and in light of the initial study that had already been drafted and put to the State Clearinghouse, it was determined that no new significant impacts were present because of the pipeline.
Okay. And I know from what Ms. Grant was telling us is we're reviewing this de novo, so it's all kind of new based on what it is today. Hence also your recommendation being changed because of what it is based off of what's going on today. I know that I have issues with the pipeline, and I'd prefer that it not be there for the fact that I know in listening to the Planning Commission, it was stated by the applicant that it was maybe not necessarily to appease the neighbors, but in order to create a buffer between the neighbors and the actual gardens. And so to me, that seems like that would be a part of the project. And so if it was still there and if it was still the plan, I would say absolutely that needs to go through CEQA for the fact that that is piecemealing a CEQA project, something that I've definitely learned about that is a big no-no when it comes to CEQA. So I'm glad that it's no longer there. And do you concur that it's no longer there?
Just to backtrack a little bit, we were under the same impression with the CEQA and the stacking of projects to come to a determination for CEQA, that's not really done. So that's why we had the applicant's consultant write the document. And under review, it's about significant impacts with CEQA, and so it was determined that the impacts wouldn't be significant. We have not verified, though, that the pipeline is gone. CDD staff have not been able to verify that yet.
Okay. I think that would be an important verification to know what the status is. There's something you said that triggered a thought, and I get it, because I think it was 40 acres. Is that what I remember reading? Approximately?
For the sunflowers?
Yeah.
I'd have to go back and verify.
Somebody said 7? Oh. Okay. Well, it was not a huge amount, and I know that in agriculture, in a agricultural zoned piece of land, you could do that without going through community development, as far as I'm concerned. So I do agree with that, but the fact that there was that wording and connecting it to the project was my only issue, and I think that knowing for a fact that that is disconnected and not going to be a part of the project I think is important. At least it is important to me. From what I hear, it's actually kind of smells bad when sunflowers dry up, so I don't know how that helps with the project, but that's a different situation. Let's go to the current status with the hoop houses. And I think that one is definitely an issue. I would suggest that there might be some CEQA coverage for just literally a hoop house, but once you add electricity to it, I am not going to argue with CDD's findings that is an issue. I believe CEQA even has, when I looked it up for the past month or so, they have like a carnival rule where putting up a tent or things like that temporarily is CEQA exempt, but this is not necessarily that, and also we could be more restrictive as a county rather than having to follow exactly what the state CEQA guidelines say, and I'll look to Ms. Grant to see if that's correct.
Well, it can be. It depends on the circumstances. Here you've got, when you were saying a de novo means you take it as the project exists. That's, yeah, how the project exists. But de novo means you're receiving evidence. So I continue to be concerned that everything's relating back to the Planning Commission, which you can certainly consider. But the Planning Commission findings are not entitled to deference under a de novo review. So I would encourage your board as you're taking, and I know you still have to take testimony from other people, and you also, I'm assuming that community development will want to speak generally to certain of the issues raised before your board deliberates. But de novo review then will be making sure that you have enough information that's been presented through this process and through the submittals, depending upon the weight you give evidence, so that you can either make these findings or determine why you cannot make these findings. So it's a little bit more involved than that.
Right. I do know that there was some comment about, okay, I'll stop because I was about to redo exactly what you said. It's just, there's certain levels of information that I feel is still important and relevant. And I guess I'll just make my comment. I have great respect for Commissioner Brown and his recognition of the cultural aspects of the project, I think, speak loudly. And so I'll just leave it at that, that is still to me evidence to listen to, and again, seeing it and discussing it today.
And Mr. Chair, please let me correct if I've given the wrong impression. The Planning Commission and what's going on before them can certainly be evidence. It's just simply not an appeal where your decision is, was there substantial evidence in front of the Planning Commission?
Correct, no.
You have to make all of these decisions independently.
Right, and I'm trying to look at what's happening today, and what did we learn from the process since July 22nd, I believe, was the approval. So I think I'm going to leave it at that for now for questions. Supervisor Scott?
I do have a question. Actually, this question would be for Anita. Because of the current code violations and the fact that they could come back and appeal the violation, how would that work if we were to grant this without any prejudice? Would that go back to the Planning Commission, or would it come to here? What happens if the fact that they do appeal it and they come to find out that these buildings were correct? I mean, where are we sitting right now? Because there's that time constraint there.
Right, well, the violations haven't gone through the entire process, but staff has testified that they've determined that there are violations currently existing on the property. Now, the applicant is saying that, he hasn't had his opportunity within the 30 days to, I'm assuming, address them. There was also some reference that it had to go to the project, but the violation says no violation of Chapters 5, which is building, grading, Chapter 17, which is subdivision, 21, which as you know is zoning, 23, which is Clear Lake shoreline, and 26, which is the aquatic plant management, currently exist on the property unless the purpose of the permit is to correct the violation or the permit relates to a portion of the property sufficiently separate and apart from the portion of the property in violation so as not to be affected by the violation from a public health, safety, or general welfare basis. Now, if your board goes through all of the findings and you feel, and again, because your board has to issue findings of fact, so your findings have to be supported by something. The staff went through and cited all kinds of things very quickly. Perhaps that was their analysis. It appears elsewhere in the documentation because obviously they would have analyzed the project and all of those components of a use permit. But your board is going to have to come up with those factual findings in support, not just, yes, we make this one, we make this one. If you can make all of them but this one, then there may be an adjustment that you can defer a decision until that is cleared up. But if you cannot, then it's a moot point. And it really depends upon what you find this violation. Technically, as it says, no violation currently exists. It doesn't say a violation's been completely adjudicated. It just says a violation currently exists. Staff is telling you that in their opinion, based upon their work for the county, that a violation or more than one violation does currently exist. So whether your board can make that finding is there in the plain black letter language of the finding itself.
So if we were to grant the appeal because of those code violations, but without prejudice, where would this applicant stand then? Where would they go back to? Would it be at the beginning? Would they just have to correct things and go to the Planning Commission? Would they come back to us?
It wouldn't come back to you. If you grant the appeal and find you can't make all the findings necessary to grant a major use permit, then this is over. The applicant could reapply.
So it would be a complete reapply.
Well, I mean, some of the information they have would still be utilized. It's not as if they'd have to go back and redo everything, but that would be an issue. Now, again, it really depends upon, you haven't really gotten to deliberation as to the findings, and you still have to hear from other people. And again, I'm assuming that community development staff may want to speak to some of the statements. If you allow, I'd like to speak to you about weight of the evidence and some of the information that you've heard today as well. Your deliberations may take some time. Your board may want to continue with all of the testimony and then continue it just for your deliberations, or you may just want to continue it if you don't feel that you can do that all today. And some of this will depend upon what community development has to say and the point of the citations to the record that they were making earlier in their presentation, and how that might support or be evidence of circumstances relating to the findings that your board has to make.
Supervisor Simon?
Yeah, and that's not complete direction, but I'd like to continue to hear, obviously, from the folks that are here to testify on it, and let's get through all of that before we bring it back. So that's where I'm at this point. I'd just like to hear, let everybody get their testimony on record here, and then we can bring it back for deliberation. So that's where I'm at this point.
Okay, let's take a 5-minute, but no worries. Let's take a 5-minute break. Oh, Supervisor Crandall?
Yeah, just real quick before we go, because I want the public to be heard as well. Because I wanted to kind of highlight that there have been a lot of discussion in the East Region Town Hall. You know that they've submitted a letter as well. But just wanted to discuss how there has been a lot of discussion in the past 6 to 8 months about cannabis and even in regard to this project. And as much as possible, each entity from the appellant to the applicant have tried to contact me, and I've tried to get them all together. I think you attended one of the meetings as well, Supervisor Sabatier, where I was hoping that they could mitigate and talk things out, things like that, because in the end, I always work for consensus. But it looks like we're having a hard time getting there. But I just want to let everyone know that in all of those discussions and deliberations, I've tried to remain as objective as possible to try to ensure that everybody's heard, even if they're not listening to each other, regardless of what. There's been a lot of key points that have been brought up by the East Region Town Hall as well. And there's other people that have not attended that have not been heard. I'm not sure if they're there or not either. So I just want to highlight that this has been heavily talked about in those meetings as well. And that any time that the applicant had reached out to me, I referred him to go to the town hall so that some of those things can be relayed as well, to try and get that out there. So I just wanted you all to know that on the board so that you were aware.
Okay, thank you very much. So let's go ahead and take a break. We'll resume this meeting at 4:10. Hey, there we go. Are we still good, Sam, as far as all streaming? All? Okay. So let's go ahead and come back and just checking in. There we go. We got Supervisor Crandall. Let's go ahead and open it up for public comment on this item. And again, if you are sworn in, please go ahead and come up to the microphone one at a time. We will also get to the Zoom room, but we will start with the boardroom. So again, those who were sworn in, we'll start there. And you have 3 minutes. Please state your name.
My name is Richard Durham. I'm going to speak with 3 different hats today. 1, I'm a realtor. 2, I'm a cannabis cultivator. And 3, I'm a cannabis cultivation consultant. So I've been coming to these meetings since like 2008. And I've seen a lot of farms get legalized, the very first ones. This has to be the most comprehensive piece of work I've ever seen. I would hate to have had to do what they've done. They've really had to cross a lot of thresholds, and they've done so professionally. I really see this on the realtor side as NIMBY on steroids, not in my backyard. I mean, when you bring a consultant, an attorney, to something that is just ridiculous. At some point, this should have been mitigated a long time ago. It's wasting a lot of people's time and money, and the board's time. And so I'll leave the NIMBY part alone. The other part, the water usage. As a cultivator, the very first thing I need is sunlight, soil, and water. Why would I not do my due diligence on making sure that my project had sufficient water? Because without water, I'm done. It'd be like you turn off the sun. You're done. So I'm sure that their diligence on their hydrology has met their project. The other one, so I get called out to a lot of grows to monitor them, disease, layouts. And this year, what I found out from several farms was they were growing with early activation, was something I didn't know about because that was prior to my licensing, or after my licensing. And I found that there was many people out there with really nice grows who couldn't dry their product. They didn't have dry rooms, and they couldn't build them because they couldn't have construction. So we really put those poor people into a really, really bad situation. You've invested hundreds of thousands of dollars to get your crop to where it is, and now you can't harvest it. And you saw what happened this October. That was really fun. I had one day where we measured 12.5 inches of rain in 4 hours. If you didn't have a drying facility, you were done. And even if you did have a drying facility, it better be state of the art because the humidity level was 100% for 17 days. So how much can you blame somebody for trying to protect their investment by putting up a temporary building? I don't think that should even be questioned. Had they constructed permanent buildings, you might have something going there. And as far as attaching electric, the pictures I saw, the fans were self-standing outside, not touching the buildings themselves. So it wasn't a building with electricity on the inside. It was a building with a fan on the outside. So in their defense, you have to dry your cannabis. It would be like having a vintner telling you can grow the grapes, but you can't crush them. You know, why'd you grow them? So with that, I'll just let it go. Like I said, I don't think that if you've lived in Lake County a long time, you don't expect your neighbors to do some farming. You do. I mean, even in neighborhoods, I see people with gardens. I live down in Lower Lake. There's goats in people's backyards. These people complaining, cannabis is only going to use up 80 acres of 1,700 acres, or 1,639 acres. Is it any other agricultural commodity, they could irrigate the entire 1,600 acres. Then we'd have a water issue, and they wouldn't be going through this. Was that the 3 minutes?
No, that was,
I once sold a house that the neighbors had 4 pigs next door, and they were growing them for 4F, And we could not close on that property till the pigs were gone for 1 month because of the stench. So cannabis is not the worst stench you can get. And it's only a 2-month thing, actually maybe 6 weeks.
and if we can get to our final comment.
I think that this project should go through. I think we've put these people through way too much. Thank you.
Thank you. Thank you.
Hello, I'm Mary Draper, and I just want to touch base on one thing. They talked about the appellant's attorney, who's also Barex's attorney, that I had sent an email to Bruno concerning the hoop houses. And I did that out of respect to Bruno. Tom and Ellie had emailed Susan Parker more than 3 times saying that this was absolutely an immediate need. He absolutely had to dry. And EJ and Bruno were both CC'd. Not all 3 times, I don't think. But when they determined that they sent the final letter to Susan Parker and stated because other people are doing it, because it's been approved, because we have no other object or no other ability to dry a product, because there's nothing in the ordinance says that we cannot do this, and you haven't responded to us, we're going to proceed. So when they sent that, I sent an email to Bruno out of respect, telling him they're going to do it. And that was the only reason. It had already been sent to Susan Parker. It wasn't some sort of secret email. And yet it seems to me that what was portrayed today was like it was some sort of, Bruno's accepting that it's okay. And that's not it at all. It was letting him know, being totally clear, and making sure that we didn't jab him in the back by not letting him know. I wanted to be totally upfront with him. So that's all that was about. Thank you.
Thank you for the comment. Can I ask a favor? Since you are the appellant, we want to make sure and give you the time. I don't want to limit you to 3 minutes. You will absolutely have the chance to speak. You are the appellant. I do not want to disrespect that formality. Yeah. And so if we can leave it open for public members who still wish to speak on this. I thought it was going to be the whole room. Please.
Well, it's good afternoon now, Honorable Lake County Board of Supervisors. Thank you for considering our appeal. My name is Maria Kahn. I am a property owner in High Valley, and I've had the privilege of living within its beauty and solitude for 21 years, 2 years before Brassfield was even there. I'd first like to say that I believe the Planning Commission erred in approving this hours project based on the faulty data. Can I remove this?
No.
No, okay.
Please.
Okay. Based on the faulty data and documents provided to the county by the applicant, and that the commission failed to seriously consider and investigate the impacts being presented to them by the residents. As a nature lover and advocate, I have enjoyed the quiet, unspoiled openness and beauty of the land, animals, and skies. I am an avid daily walker, and I stargaze at night. I'd like to share with you examples of how the granting of UP 2110 has been detrimental to public health. Physically, pollutants such as dust, pollen, exhaust, pungent odors, and chemical drift cause life-threatening harm to our residents, especially those who have breathing issues such as asthma and COPD. I walk my dogs every morning on High Valley Road. Since the Sours operation started in May, I have been impacted by a huge increase in traffic traveling in both directions, having to step off the road into the ditch sometimes to avoid injury to my animals or myself. The amount of gas and diesel exhaust is offensive to breathe, and several cars fume of cannabis smoke as they pass by. During the grading in May and June, I choked on dust and felt the grit in my throat and sinuses daily. I've experienced increased stress surrounding all the issues this operation is causing for our valley community, our wildlife, and the resources that include picking up their litter, loss of sleep, unsafe impaired drivers, constant industrial noise from fans, generators, and traffics 24/7. This goes around the clock every day. And having to defend our rights and protect our way of life against an organization with endless money and political influence. Mentally, the constant sound of machinery to a person accustomed to nature's silence becomes maddening and intolerable and starts to wear on the psyche to the point of harm. I am experiencing such harm. People who live in the country are very connected with nature and notice subtle changes in their environment. And an operation this big is a huge, complete lifestyle change for the ones who are affected. It has disturbed my mental tranquility and peace of mind. Emotionally, as decades-long residents, I have been fortunate to join my neighbors in being stewards of the land. Within 7 months of this year, I have watched the desecration of half of our valley, which gave yield to an organization that doesn't respect our way of life, nor do they seem to care. While promised many things, the residents of High Valley have received little consideration for the disruption of the way of life that they have strived to create, and any hope that their dreams for the future will be sustained or even realized.
And if it's possible to get to your final comment, I believe that was the 3-minute beep.
Really? That fast? All right. The safety issues, we don't know who's coming in and out of the valley anymore. We used to call each other and let each other know. Our welfare, none of us are happy that this is happening in our valley, even though some people are not speak up, some people are afraid. The constant activity is just going on always. So we would ask that you protect the rights of the property owners and the residents in High Valley and deny any future applications for large cannabis operations in our valley as well, because there are things that are in the pipeline and that we're concerned about those as well. So thank you so much. I appreciate your time, and I ask that you grant our appeal and deny this project.
Thank you.
Good afternoon. My name is Melora Valentine. I live across the street from Sowers HVR. And the pictures are authentic. I watched the dust cover the entire valley. I'm not talking 100 feet, the entire valley. The noise, the fans are on all night. I checked out the hydrology report, and I have grave concerns that it is incomplete or inaccurate. They talk about the High Valley Water Basin being more than capable of sustaining this project. However, there is a well, and on your paperwork it is 34. It is a state-monitored well. It has been monitored since 1959. It is my well. It has shown greater than a 50% decrease since Sowers started. It is in direct line with wells 4 and 7 that they utilize for their cannabis production. The state doesn't lie. You've got 62 years of records to show what's happening with our watershed. The valley cannot sustain what's going on across the street. My question is, when my state well fails and it measures the health of the High Valley Water Basin, who's responsible? Who's liable? The county for approving it, or Sowers for making a project too big for this valley to sustain? And final comment, because Brassfield and Sowers believe that they own 56% of the valley landmass, their cumulative impact gives them the right to take our water resources for their projects. It's unfair, it is unjust, and is unacceptable. Thank you.
Thank you for the comment.
Good afternoon. My name is Brian Valentine. I'm here today to state my opposition against the project for many of the reasons that were brought up: the noise, the smell, the traffic, the destruction of our environment. I am also deeply concerned about the water usage. There is a direct correlation in High Valley with the current state well that was just spoken of. its water levels decreased over 50% over the yearly drop. That is far outside what was brought up in the hydrology report, and the hydrology report omits or does not have any information about that well to make an informed decision. It is my opinion that if the county were to approve this, they are approving it on incomplete data, and it could very well damage the health, safety, and welfare of the High Valley area. Today was officially brought in as Native American History Month. There's been plenty of destruction of land and heritage. Are we not at the point that we know better? At this point, we need to do what is right, not about the almighty dollar. We need to preserve our resources for future generations. Thank you.
Thank you for your comment. Any further comments from the board chambers?
Hi, Brad Stoneman with Kimley Horn. Just wanted to touch on traffic real quick because there's been some consideration of that. Typically, CEQA requires looking at the existing conditions versus what the project will do to those existing conditions, and traffic is somewhat unique. For example, like if there's a shopping mall and they're going to reuse the shopping mall for mixed use or like a high density residential project, what you'll do is compare the existing trips to the trips that would be generated by the new project. So you can come to a evaluation or conclusion on the number of trips that would be generated. That's appropriate. Just wanted to point out for the project in terms of what we did was compare it to the SCI seminars. Obviously, the applicant has talked about that before. What they ended up having was about 58 average trips per day. Averaged out over the year. It's more efficient to do that because there's punctuated attendance to the seminars, and it's not really reasonable or feasible to look at that single day or those 5 days or 10 days over the course of the year. So we compared that to what we would see with the project, and in the project description, 30 to 40 employees per day. Even if it's higher than that, still that's at the height of cultivation. Right now, there's more people out there than there would be. The other 4 months out of the year, when other cannabis activities are going on, that number is going to drop down. Over the 6 months when there's no activity going on, that number is going to drop even further. So we average that out over time. I did want to discuss, though, in the VMT memo, there is the discussion of intermittent need for truck trips, and it also discusses that deliveries would occur, typically in van-sized vehicles, car-sized vehicles, that sort of thing. So that is discussed, and in comparison to the existing conditions, again, SCI seminars, that was fewer trips than that. So just wanted to thank you.
Thank you for your comment. Any further comments inside the boardroom? No, I'm going to go with new comments before I come back, and depending on time, I may not have the chance to come back because I do want to try and bring it back to the board so we can at least have a little bit of a deliberation in case we require further information or data if there's a continuation. And I do not want to keep staff longer than 5 p.m. here. And unfortunately, this has taken quite a large amount of time, and I think we're all dedicated to providing whatever time is required for this. But just wanted to at least make that statement that that's the time frame that I'm looking at. And it seems that we might come back earlier since I'm not seeing that many hands. But let's go to the Zoom room for first comments, and we'll get to the applicants and the appellants and all that again. So let's start with Angie Dodd.
Thank you, Chairman. I'm Angie Dodd. I'm with North Point Consulting, and I did write the review of the hydrology reports and the analysis within the ISM&D for this project. I raised my hand because the applicant had mentioned that they were going to they would have their hydrologist available for questions. I just wanted to let you know I'm available for questions. I was asked to review the analysis to evaluate if there was substantial evidence to evaluate that there's no impact to groundwater resources, which I felt that I did. There were a lot of data and information that were not incorporated or included in the analyses for the proposed project that would substantiate a lack of impact without implementation of mitigation measures. Not one mitigation measure was included. Well number 4, which is a project well, is a California statewide groundwater monitoring program well that is monitored by Lake County Water Resources District. That well has been monitored for years. It has a rigorous methodology for monitoring, and that was what the tables and data were based on, or sorry, the charts and data were based on in my review, showing a long-term increasing trend. But the importance is that within the short term, last 10 to 20 years, there has been a decreasing trend in the valley. This is a reputable well, reputable monitoring well, so it's very important to understand that impact. The other thing I want to quickly point out, and then I'll be done unless you have more questions, is there was no analysis, no quantification or even qualification of what would happen during a dry year or multiple dry years. I think that's really important to have some sort of quantification or qualification to determine if there's an impact or not. That information was just not provided so that that determination could be made. So I'm here if you have any questions, and thank you.
Thank you very much. Next is Bobby Dutcher.
Hi, Bobby Dutcher, Lakeport. I was on the first cannabis committee that the county formed like 12 years ago, I believe, with the supervisors Denise Rushing and Tony Farrington. So we have been involved in this topic for a long time. I also was at the very first use permit hearing, and so I'd have to agree with Commissioner Hess after going through all these and watching these all the time. This is one of the most comprehensive applications that I've ever seen. And since it's one of the largest also, I'm sure there's a lot of room for subjective opinions on whether or not, like the water study was done correctly or incorrectly, and it's not really an exact science. So there's a lot of opinions and I guess subjective feelings on that. The fact that we just went through one of the worst drought years that we ever had, and they did operate, and I haven't heard of anyone's wells going dry. That was a pretty good test of the project. For the dust, I saw that one video of all the dust that was flying off there, and it looked like it was a very windy day, like in the way the trees were shaking. I've done over 300 acres of agricultural crop conversions here in the county, usually going from orchard to vineyard. And unfortunately, that's what they look like in the summer. That dry dirt turns to dust in our 100-degree heat in August, and when the wind blows, it blows the dust around. So on all the clearings that we've done for vineyards, that's what they look like in the summer. When it's vineyards, they seem to be held to a different standard than everyone else. But with a cannabis project, the same with a vineyard project, once you do it and the crop is planted, it doesn't happen again. So I think that the dust problems that they had this year are not going to be repeated in the future. You don't see dust blowing off of a planted vineyard. You probably won't see it off this cannabis project as well. So again, I agree with the Commissioner Hess. I think this is a very comprehensive application that they've turned in. I hope that they keep going. It's unfortunate they built those buildings, but yeah, if they have to process it somewhere, and they weren't allowed to build it because of the appeal, I think they just kind of got forced into that, which is unfortunate, but hopefully that could be straightened out. I certainly don't think that should cost them their project. So yeah, I still support the project and I hope they can work things out with their neighbors.
Thank you for the comment. Next is Jason Sheasley. Hopefully I said that correctly, but if you could provide your name, and you have 3 minutes.
My name is Jason Sheasley. I am with Kimley Horn and Associates, and I just wanted to point out a couple of things. First of all, when we started this process of evaluating groundwater at the site, we did not have the benefit of the current ordinance code that outlines the specific requirements for the evaluation. And when we talked with staff, they were very vague in what they were looking for in the report, other than to say that we needed to evaluate and ensure that the proposed groundwater withdrawals will not impact any of the adjoining well owners. And so what you see in the hydrogeologic evaluation was based on that initial assumption. And we looked at the existing well number 4. We evaluated the hydraulic and estimated the hydraulic parameters of that well, and then determined what the corresponding radius of influence would be if you use that well and other wells to meet the groundwater demand for the project. And the radius of influence for that well and other wells did not encroach on adjacent property owners and did not impact any of the nearby well owners. With that, I'd also like to state that when I reviewed the report that was prepared by High Point, I wanted to point out a couple of things. It's predicated on the assumption that only well number 4 and well number 7 would be used to supply water for the operation, and that is not the case. We just evaluated well number 4. We clearly state that additional wells would be required to meet the total water use demand. So I think evaluating or looking at or making the assumption that we're just going to get all of the water out of 1 or 2 particular wells is incorrect. Also wanted to point out the issue regarding the water from Brassfield Estates. Regardless of whatever that water was used that came from Brassfield Estates, it's important to note that that water is groundwater. So if that water that is in the pond that came from Brassfield was produced by wells that are pulling water out of the aquifer that supposedly is not capable of meeting the water use demands for the operation, and that's just not the case. The other thing I wanted to point out is that in the Northport report, they indicate that the poor functionality, quote, the poor functionality of wells 2, 5, and 6 is an indication of groundwater availability, and that's just not the case.
And your 3 minutes are up. If you can just finalize your last comment.
Sure. I just wanted to say that there were multiple wells installed on the site, and wells 2, 5, and 6 were installed back in the 50s. Those wells have deteriorated over time, and the reason they're not being used is because the integrity of those wells has been such that they're not usable. So it has absolutely nothing to do with groundwater availability more than the integrity of the well itself, and they need to be abandoned and replaced.
Okay, thank you very much. Any further public comment in the Zoom room before I bring it back to the board? Jennifer Smith.
Am I unmuted?
We can hear you.
Hi, this is Jennifer Smith. I'm going to remain steadfast in my opinion that this project meets the land use components of our county's cannabis program. I think there's been a lot of subjectivity and a lot of biased input, and worst case scenario, probably some new information should be reviewed. Best case scenario, this project should move forward. This is a landmark situation. This sets the tone for the rest of the county and the projects that are in the queue. I think this makes a statement for whether or not Lake County wants to have cannabis here in an area that is zoned appropriately. I'm not going to get into the specifics of some of the commentary today, but the fact that there is a winery right next door and they are allowed to use pesticides much worse than cannabis are, when cannabis is tested to the parts per billion and wineries are tested to the parts per million, the fact that cannabis is being blamed for pesticide drift or potential pesticide drift is absurd. And I think that this has become an emotional issue. I think we are creating problems where there are no problems. And any issues that have come up have been addressed. They have not been egregious in the eyes of the regulating party. Fish and Game has been satisfied. The county has been satisfied and has the potential to continue to be satisfied. Again, I'm going to continue to support this project. I'm going to continue to support projects that meet the zoning for which we have set forth. And with that, I appreciate your time. Thank you.
Thank you for the comment. So I'm going to bring it back to the board chambers. I believe we had one person who wanted to do a repeat. If you can keep it succinct.
Hi again, I'm Maria Khan. I have been the one that has taken most of those pictures along with my neighbor. We can provide you with the originals that were used in this presentation if you saw, and I have actually directly emailed you several pictures and videos. So if you need those, we have those as well. So also the issue of water, yeah, there may be water, but that property has never had good water. And Ellie himself described that water as being too spicy, which means, in my mind, it's probably not good for their plants. So they have been drilling wells all over the place and eventually hooked up with Brassfield to get better water out of the aquifer. Thank you.
Thank you. And with that, I think I'm going to close public comment and bring it back to the board. It's 4:41. Would we like to hear feedback from our staff based on some of the information that has been provided by both applicants and appellants, or would we prefer deliberating at this moment in time?
Mr. Chair, I don't think you heard from Mr. Van Pelt.
Yeah. Okay, so I guess we will reopen it up but I would like to go in the same order that we started, which is the staff to begin with. If there was any further comments based on the testimonies that we've heard today, any corrections, any additions?
Testing. I believe that the biggest comment from staff would be on the determination of structures and construction in regards to the violations. The main argument that we're presenting as far as the violations is that in order to assess whether or not what type of permit is needed, we need to see the information. So I'm just going to reiterate one paragraph from my presentation earlier. The construction type and fire rating of the structures viewed during the October 25th, 2021 site visit are in question due to lack of building plans for review. Items such as allowable floor areas, maximum height, flame resistance, thickness of material, etc. would need to be provided to staff as part of the project analysis in order to apply the appropriate regulations. Because they were not included as a project element for either permit, the EA or the use permit. Staff does not presently have the information for an analysis.
Okay, thank you for that addition. Let's go ahead and go to the appellant. You had something further to add?
Mr. Chair, then I believe you'll have to give equal time to the applicant,
yes,
of course.
Good evening again. I just wanted to state during the applicant's presentation, he mentioned photographs of where they didn't come from. I personally have photographs of multiple light towers in August. I have pictures of the pipeline on October 25th coming into Brassfield, coming out of Brassfields going under High Valley Road. And I also have pictures right from my backyard looking at their hoop houses and listening to the noise. Yes, granted, it's very hard to get the noise on a cell phone, but it's extremely noisy. So for them to say there's no noise, the county staff in their own report mentioned at the site that it's very difficult to have a conversation at the hoop houses. That's the staff's own words, not mine. And that's all I have to say. And I think Mr. Johnson has a few things to say.
Looks like it.
Yeah, thank you. I'll keep this very, very brief. I just want to get the board focused back in on what the applicable legal standard is here. This is an initial study mitigated negative declaration, which means that the board must be able to conclude that there has been no substantial evidence submitted today that is indicative or supportive of a fair argument that the project may have a significant impact. Not will have a significant impact, but may have a significant impact. Substantial evidence is a defined term of art in CEQA. It relates to a very specific type of evidence that is substantial, but it doesn't mean it is, as has been represented today, direct evidence or actual evidence. Those are not legal terms. So substantial evidence is defined in CEQA, It has a very specific meaning, and that substantial evidence has been submitted today indicating that a fair argument exists that the project may have a significant impact related to odor, traffic, biology, water, noise, and other issues that we have talked about. I do want to clarify, a statement was made that odor is exempt from regulation. Odor is not exempt from regulation. Full stop. A statement was made that CEQA is about significant impacts. It is not about significant impacts. CEQA is about public disclosure, which is why a full and complete project description is an essential and foundational requirement of CEQA. As County Council has stated, your review today is de novo. So the project before you involves hoop houses, generators, and all the activities that neighbors have complained about for the last 6 months. Those are the fullness of the project. So the question for you, just on the project description, are those elements included in the project description or not? They aren't. Finally, a statement was made that this is an agricultural product. The law is unsettled on that issue. Business and Professions Code, which is out of MCRSA, which is the state cannabis statute, states that cannabis is an agricultural product for purposes of this provision of MCRSA. There is no statewide understanding that cannabis is an agricultural product, and indeed many counties across the state have specifically excluded cannabis from the right to farm ordinances for that reason. So I do want to make sure that the board is not misled on that point. Again, we do appreciate your time and ask that you deny or uphold the appeal. Thank you.
Thank you for your comments. And the applicant, if you would like some time.
Thank you. George MacDonald on behalf of the applicant. Again, to touch base again on Brassfield, it has been removed. The pipe is removed. We would invite code enforcement out to take a look if they'd like. That goes the same with these hoop houses. They're in the process of being removed. Weather permitting, the time it will take to do that, we fully intend to have it done within the 30-day period if no appeal is filed. And again, we'd invite code enforcement to come out and take a look. CEQA is about public information and information gathering. I don't think anyone's going to doubt that there's a substantial amount of information that has been gathered and provided to the public here. It was available on July 22nd when the Planning Commission made a unanimous decision to approve this project. In cannabis, it is agriculture, plain and simple. It's grown with the sun, in dirt, it's plants. It's regulated by the California Department of Agriculture. It is agriculture. I'm not aware that this county has made an exception regarding the Right to Farm Act or ordinance. I don't think there is one here. So right now, as this presently stands, it is agriculture and has all the full rights as a winery would. Also, these hoop houses, right, they have not been here for months and months. They were put in, I know code enforcement can confirm actually, just a couple of weeks ago, and they were installed with all hand labor, and now they're being removed less than 2 weeks later. So these aren't things that have been there for 6 months, right? Any noise associated with that, the fans are specific to these hoop houses, so they've only been there a couple weeks and they're now being removed. So it's not correct to say that this has all been going on for the last 6 months. And I think that the comments that code enforcement have received really started about October 25th. And that shows as well that this is something that ramped up in anticipation for this hearing today. Thank you.
Thank you very much. So bringing it back to the Board of Supervisors. Supervisor Scott.
I want to go back to Anita and have her explain a little bit. She was talking about evidence and weighing of evidence. You could pull us a little.
Thank you. You have a great deal of information that's been provided to you and some level of analysis. You have heard from the attorneys. The attorneys are making their case, they're making their argument, they're not presenting evidence, they're telling you what they believe the evidence shows in a particular matter. In an administrative hearing such as this, the rules of evidence are generally quite relaxed. However, your board can always require some authentication of evidence. The issue of photographs, who took them, when they took them, what they took them, where they were when they took them. All of that is relevant to your board. Now, your board can admit them anyway and determine that you find them credible for whatever reasons you determine that. You can assess them as having low, they should be afforded a relatively low or little weight, given that they haven't been authenticated. There's been some commentary that could happen. Your board could additionally require testimony to authenticate the photographs so that you know whether they are of the project or something else. As far as the fair argument standard, it is certainly true that lay commentary on non-technical matters can support a fair argument standard. However, it is not the existence of public controversy, the existence of disagreement itself is not enough to support substantial evidence. Your board has to go through and determine that. There have been a number of citations to things that I'm assuming the staff cited as evidence of various propositions that your board will have to go through because there hasn't been a discussion or an analysis of what each of those citations relate to. So I'd encourage you to do that before making a decision. As far as some of the commentary that you've heard in terms of motivation, et cetera, your board has to determine the appropriate level of environmental review. Your board has to determine whether you can make the findings to justify a major use permit, and those findings that are required for cannabis under 27.13 AT. So your board has to make those findings, and the factual support for those findings have to be discussed by your board so that you can determine that there is evidentiary support for each finding that you make, and your determination, again, as to the appropriate level of environmental review for this project. If you believe that a fair argument has been made that there is a substantial potentially a substantial impact on the environment, then your board does have to look back at the environmental review, and you cannot make those findings today. If your board finds that any of the elements and for a major use permit under 51.4, you have to make each and every one of those findings. And I've heard a lot about, there's nothing in the ordinance, or hasn't been anything in the ordinance about the level of water. Well, water's been an issue in this county for a number of years, and anyone who's lived here for more than a minute also knows that there is a great deal of recurring drought conditions, and the findings that are required for approval, one of the issues is adequate public or private services, including fire protection, water supply. So that's always going to be a concern. As you look at the studies and the evidence presented and any analysis that's been provided by community development as the lead agency on this project, you're going to have to determine if you can make those findings, and that's essentially and again, as far as the evidence that's been submitted, the weight you want to attach to that, and again, keeping in mind that council are giving you their opinions of what this shows, but it's your burden as the board to determine what you believe the evidence shows and how that evidence then either supports or prevents the findings that your board has to make in these proceedings.
Thank you very much. Anything further? Supervisor Simon.
Yeah, I'll just address, I did have one question on the hoop houses. I think a comment was made by the appellant when they put it in, and I know we saw some pictures, and you say they're not permanent, but how were they staked to the ground? How were they, I know you talked about it a little bit, were the four corners concreted, were they staked?
Yes, that's a good question. They're not in concrete. They're not in anything like that.
How are they secured to the ground?
There's actually just screws, and it's my understanding you do it with your hand. And these basically are glorified tents. I know they look much larger, but you screw them in like a tent stake almost. And that's how it's done. There's no digging, no tractors, no excavation. And that's why the photo actually shows when you take them out, the land looks the exact same as it did before. There's no trenching, no digging, nothing, no plumbing. The electrical line from the generator all above ground.
I understand that. I was just wondering how they were secured to the ground so they didn't blow away or something like that. We had some extreme storms.
The statements made to us.
Can we get a mic over here for Marcus, please?
The green light's on. I think it'll.
The statements made to us while we were out on the site is that they are ribs, and they are buried 6 inches in the ground, and then they also are anchored down by screws. But they, again, our position is they are not hoop houses. They do not meet the definition of a hoop house per Chapter 21 of the Lake County Code.
Okay. You can clarify that.
Hello?
Great, thank you.
Sorry. So in my presentation earlier, I outlined the definition of hoop house and greenhouse from the definitions in the Lake County zoning ordinance. The structures that we saw did not match these definitions. If I can I just read the definitions one more time? Hoop house is defined in Article 68, Section H, Part 9 of the Lake County zoning ordinance as an unheated outdoor enclosure used for the purpose of growing and or protecting seedlings and plants from cold weather, but not containing any mechanical or electrical systems or storage of any items. Typically, a hoop house is of semicircular design, made of but not limited to piping or other material covered with translucent material. The hoop houses that we saw on the site were made of an opaque material. There was also electricity within the hoop houses.
From the generators.
And I'd like to expand on that. It's not just the fans. They actually had lights in there connected by extension cords. And also they had, in one instance, a propane heater in there.
Okay. Thank you.
Thank you for that. Yes.
So just to clarify, the staff position is that these are structures, but in order to determine what type of structure they would be and what type of permits would be allocated to those structures, we would need to see plans submitted to the Community Development Department in the form of a building permit and most likely a zoning clearance, so that we, as staff in the Community Development Department, could assess what types of permits were needed for these structures.
I'd just like to chime in one more time. There is, to my knowledge, a building permit available for temporary structures that could have been applied for.
Okay. Thank you.
And is that possible during, as somebody just asked, and I think it is a good question, is that a possibility during an early activation? Would that be allowed when it says no building construction?
So from a code enforcement perspective, that's a determination that would have to be made by the planning division.
Gotcha. Okay.
Probably most likely in consultation with the building safety division.
Okay. Thank you for that. So it's four.
One more comment, just.
Please.
One more comment. I know, going back, I think there was a comment made by Mr. Armstrong directly about some conversation I may have had when we were talking about odor. I think he had a specific one, so maybe you watched the video, because I didn't watch a video on that specific comment that I made. But I know in the past I've made comment that, we really are moving towards with cannabis. Cannabis has been here. If you've lived here all your life, people have been growing cannabis in Lake County, legal or illegal. That's the bottom line. You smell it every September, October, and going forward, the reality is most likely it will be legalized in the future at some point. I don't know when, and it will become an agricultural crop. So here in Lake County, it will be part of our ongoing lives. So that smell, and I think some of my conversation was, how do you control that? Because even if you've got the most advanced filtration system and everything like that, if you're growing 80 acres of cannabis, which may happen, or 25 acres, that smell is going to be really hard to control in these areas. And I think that was more of my comments when we were talking about that, of the reality, the world we live in. Maybe it can be completely controlled. I don't know. If you guys have seen a project like that anywhere in our county or others, please let me know, because you get the same smell, the same drift when you go to Sonoma, or you drive through Mendocino, or you go through Willits. You get those things in the other counties too. So anyway, I just wanted to address that That's probably where my comments were coming from. I guess I'll have to watch the video now that I was quoted on that and make sure I have it right. So for me today, and listening to the evidence and what is presented to me, you know, I do think that we're going to need some more time to deliberate on this. That's my feeling on it, but we can go if someone's ready to move forward with something, that'd be fine. But we've taken in a lot of information. It was a very important decision, but that's my thoughts on it.
Okay, thank you very much. Supervisor Pyska?
So in July, we wrote the emergency ordinance that was specifically in response to the request that came from the Planning Commission for this application. And I think it's prudent that we apply that ordinance to this application. We can send it back to the Planning Commission for that extra review. And my concerns also with the hoop houses are, you know, that issue needs to be resolved with code enforcement and with planning.
Okay, thank you very much for your comments. So yes, there is a lot of information. I think it's necessary to kind of review it. I do have a request, if it's possible. I know there was some information brought to us about a state well that data is tracked, and I'd love to see that. I'd love to also know how deep that well is. Is it coming from the state, the same levels as what the project at hand here is taking water from? Just so we can get an idea of what is the impact, because I think it's important. We have the situation where we kind of have an example of how this would impact the community, and taking a good look at that might provide some information. Maybe it doesn't, I don't know, but I think that asking for it, if it's available through Water Resources, that would be a useful piece of data to kind of take a look at. Yes?
Can I clarify, was this request for well number 4?
I believe it is number 4, yes. Or at least the one that is state data driven, or it's recorded by the state. And at this moment, we don't have public input, but if you can provide that information to our staff, because I believe it was your well that we were looking at, and that's the one I would... Okay, so we have 34. And I don't know if this is necessarily within our purview, because there's obviously there's an issue within what's happening on the project site and the hoop houses. I think that is an issue that is a glaring issue. But at the same time, and this is where the purview, I don't know where it is, to me, putting it back into the Planning Commission, and it's just going to come right back here. Because obviously there's some issues with the neighbors, with the size, there's some issue, and so I'd love to figure out a way to solve the issue. I'm in the mindset of we can find a way to say yes, and is there a way to compromise the situation versus just a straight yes or no. By looking at this project and looking at better conditions of approvals or things of the kind. But again, I don't know if that's just, I just hate to see staff's time being wasted on reoccurring, trying again, because this does take a lot of staff time for the process, let alone the appeal process as well. And it's also a waste for both the neighbors as well as the applicants. And so I'd love to possibly find ways to be able to find a way to move forward. So I also believe that there's very many conversations that were had about the exclusion zone. The exclusion zone is now an issue. And I think that part of that process in finding the exclusion zone was to say that there would not be a significant impact to the welfare and health and so on and so forth to those in those areas. And there was a lot of conversation, a lot of workshops, and that doesn't mean that there's nothing that can't be done to, maybe there was a mistake and maybe we need to review those things. But it's when it comes closer and closer to individual people, there's a different reaction than just looking at the exclusion zone. when again, there was quite a thorough process in order to get to that. And we kind of pushed cannabis to the outskirts of our communities, and now even in the outskirts of our communities, it seems to have a struggle in getting there. And so that's some of the struggles that I'm going through, is the processes we've put in place, the processes we've followed through in order to get with the ordinance that we have to the point that we have it. It's a complex matter, and with the extra 145 pages, I believe, is what we received yesterday, with quite a majority of pictures at the end of it, but that needs to be reviewed as well with all of the rest of the documentation that we've already received, plus the new information that we've taken in. And so I would like to request, it is 5:06 p.m. I'm sorry, I kind of promised you all that you would get to leave at 5. I would like to request a continuation of this public hearing on...
Shut my door.
Yes.
Oh, so glad that our CAO's here. I'm thinking that it needs to be in the first week of December, because I don't know that we have the capacity in our agendas to add it in on 11/23 or 11/30. I know we have some interviews potentially coming up. I want to make sure we have time set aside to be there.
Here, let me take a quick look at what we have cooking in for those meetings.
And kind of looking at my colleagues, is that...
So at this point, Mr. Chair, shall I speak, or do you wish me to wait?
I do know that Supervisor Simon is thinking.
Let her go.
Okay, CAO Hutchinson.
Thank you. It does sound like on December 7th that your board may be interviewing some of the unfilled positions to which you appoint. The 14th of December looks wide open from my perspective at this point, but I'll also check in with Johanna as our assistant clerk of the board. Johanna, do you have anything for the 14th of December?
No, that date is good.
So the concern I would have about December 7th, Mr. Chair, is if you need to reserve a block of time for appointee interviews, you would need that time that day.
Yeah, no, I don't want to mess up the filling of positions. It's too important that we have time set aside for that, and ample time to be able to do the proper interview process. And so looking at my colleagues, if December 14th is adequate?
Yeah.
I'm getting some yeses, and I do have a hand up from Supervisor Crandall. Sorry if your hand's been there for a while, I have not noticed.
Yeah, no, I wanted to just say something before you went into this, because I had a feeling we might want to be moving forward to another date. I understand that. I kind of wanted to speak after everyone spoke one last time, and I don't know if you would rather me do that, or would you rather just wait till the 14th?
I am not going to control your ability to express yourself freely.
Okay. It was brought up about Mr. Butsulwin Brown, who is the District 3 Planning Commissioner. And initially, in watching the Planning Commission meetings and reading the minutes, noticed he was in opposition to this project in the initial stages. And then he had actually went out and done a site visit and changed his mind. And the reason I highlight him is because in appointing Butsulwin Brown, he is extremely qualified in Tribal Historic Preservation Officer. When I was a planning commissioner, he would come to meetings and I would have to hear some of the things he would say about it. And so with that in mind, I know that there's cultural relevancy to things that I know if he wasn't okay with it, he would have spoke it then. So I know in the aspect of that, that's where that's at. And so in the beginning of these deliberations, when it came to the Planning Commission, I watched them because I knew it was very controversial as I've heard about it. I had spoke with Mr. Van Pelt and I can't think of his name, but I had spoke with Mr. Van Pelt and his consultant back in May, but it was not about this project. We were talking about another project in the Lake Recovery Project in Spring Valley. And so in July, when this passed, then Mr. Van Pelt had started to come to EARTH meetings and expressing This is also when I expressed earlier that I would try to get both parties there to ensure that all of these things have been brought up before. I've heard all of these things continuously. I'm not sure that even if we move forward to that date, we're going to get anything but just more stacks on each side going up, because each person I talk to doesn't necessarily have an objective point of view towards the other side. It's either all or nothing. And so I do appreciate one thing that a young man had said and another lady had stated about being Native American Heritage Month and they understand how the natives feel. And I'm glad that in some instance they can relate. You know, I'm glad that they have the voice to speak this. And I'm also glad that they don't have to endure the hardships that our ancestors endured when they didn't have a chance to speak in these courtrooms like such. And in a way, you would think that there would be some sort of mindset that I would want to impose that onto these folks for the fact that that happened to my ancestors, but I don't. In turn, it makes me want to embrace them and actually vote for the appeal to be approved, because I can relate. So I had a lot more, but I don't want to just go into, I know it's late, but I would be ready to make that motion today. But if the rest of the board wants to wait, I'm fine with it. So I just want to let you know where I stand.
And I would suggest that if you feel the requirement to make a motion, do so and see what happens.
I also would like to say that I have communicated with Ellie as well during the project scope timeframe. I went up there with Lance Williams back in March. There was no grow or anything at that time. He was kind of explaining to me what was going on. So at that time, did not think it was going to affect as bad as it has. And so I did not think that it was a project to the scope frame, and it just turned to a different whole direction. I think he has good intentions. I think he tries, but for whatever reason, there needs to be more mitigation, I think, for the folks that live in that area and who are affected by this. So I would be prepared to motion to approve the appeal.
Is there more to that?
I was reading it right here because I had to pick up I would be prepared to motion to approve the appeal and and deny the use permit without prejudice.
I am assuming then that the motion's predicated upon none of the findings can be made, and you think there's a fair argument that's, well, at this point,
Yes.
just for the appeal, the findings of the use permit can't be made, and you believe that given all of the evidence presented today, that the appeal should be
Commence.
granted, which means that everything stops. Okay.
Yes.
Okay, we have a
That's a
motion
motion.
from Supervisor Crandall,
I'll second.
and we have a second by Supervisor Simon. Johanna, roll call, please.
Okay, Supervisor Simon,
Yes.
Supervisor Crandall,
Aye.
Supervisor Scott,
Nay.
Supervisor Pyska,
No.
and Supervisor Sabatier.
One of the findings that we have to make is Article 5, and that's the one I cannot get past and not sure that time will provide any better clarity. I'm sorry, but I feel I need to say some words. I know that I spoke with Ms. Parker for about a month to try to figure out a legitimate pathway for 90%. I kept saying that to Ms. Parker. This is not about sours. This is about our industry here, because there is a somewhat prohibition to be able to accomplish the goal of carrying cannabis from seed to actual product, where the difficult task of having a drying shed when none are available. And we work together to try to make that work for the industry. We were not able to do so. And on the fact that we were not able to do so, and someone took a risk to make that happen on their own, whether it's right or wrong on a personal level, as far as legally, there is an issue there. Yay or aye? And motion carries. Staff, thank you so much for your time. And have a wonderful evening. And let's go ahead and take a quick 5-minute break. We do still have some items on our agenda. And we'll be back at 5:21. Hello. All right, let's go ahead and reconvene. So we are, due to time restraints, we are going to move item 5.4, no, not 5.4, 5.5, 5.2, no, 2's already moved to another one, sorry, let me retry. Item 5.5 and 5.6 will be moved to the 11:23 consent agenda. Actually, let's not put it on the consent agenda, all right, it will probably be resolved at that point.
It'll be resolved and put on the consent agenda?
Okay, because it was just a clarification, typo, or something that needed to be resolved.
As
And then,
will 5.15.
and 5.15 will be again on the consent agenda. Then we are going to push 7.2 to 11:23. We are going to push 7.3 to 11:23. And we are going to pick up and do item 7.4 right now, which is consideration of advisory board appointments, first 5 Lake County. Are there any questions about the extended terms from the board? Seeing none, let's open it up for the public. There's still some with us on Zoom. Any comments on this item about first 5 appointee? And let's bring it back to the board for action.
Mr. Chair, I move to approve Allison Pinella and Carly Sherman-Swatosh at the first 5 commission meeting. Reappoint.
I'll second.
We have a motion from Supervisor Scott, a second by Supervisor Simon. Johanna, thank you for sticking with us. Roll call, please.
Okay, Supervisor Simon,
Yes.
Supervisor Crandall,
Aye.
Supervisor Scott,
Aye.
Supervisor Pyska,
Yes.
and Supervisor Sabatier.
Aye.
Thank you.
And then let's do, are we able to do 8.1? Is somebody available for that?
I've reached out.
Okay.
I don't have an answer yet. If you
Let's go
want
ahead
to
and do
your
calendars, and let's start with Supervisor Crandall.
All right. So first, I want to say that sorry they couldn't be there in person.
We're happy you're there.
Yeah, I was going to say, we're glad you're not here.
But yeah, so tomorrow, West Region Town Hall, probably trying to do it from Zoom. Probably, I'm going to go try and get a COVID test right in the morning over at Tribal Health. So if I can get that quick test that says that I'm okay, we'll see what happens from there. But more than likely, be doing that on Zoom. Clean water program on Thursday meeting. Clog was at 5 to 6:30. Not sure if I'll be able to make it, depending on my test or whatever that happens. 6 p.m. Lucerne area town hall. So I'll have to figure out that one too, getting a Zoom in or something like that. But I know the agenda's been put out, so I got the LAF meeting that night too. Monday CAO meeting, then back here next week for the board supervisor meeting.
All right, thank you very much. Let's go with Supervisor Scott.
Tomorrow, I have a first 5 commission meeting at 2 o'clock via Zoom. On Thursday, I have, I believe it's a mental health advisory board, but I know those are showing up weird on my calendar, but I believe that's tomorrow at 3. Friday, I will be attending the Candlelight Visual at Library Park, lighting candles for our suicide victims and their families, and then hoping to come over here for the Kelsey Brothers talk, because I missed it the last time at the stage stop that I was planning on going. And then on Monday, I have a Safe RX meeting at 10:30, and then the Scotts Valley Community meeting at 5 p.m., and then getting ready for Tuesday's meeting. That's all they got.
Thank you very much. Supervisor Pyska.
So just to report a little bit on yesterday, we had a Risk Reduction Authority meeting and Supervisor Simon wasn't able to attend. The group has, what? No, it
I was just giving you a hard time for calling him out.
No, I'm
You
just
had good
reporting
reason.
for
Good.
him because he's the chair and he usually makes the report.
Sorry, it's getting late. I didn't mean to divert attention.
So we, as a group and with the many nonprofits, we've been working all year on our strategies of building out the RRA, building out the Fire Safe Council, and figuring out where everybody fits in. And it was another really great collaborative, cooperative meeting, but they are all kind of starting to look at the county for us to figure out our role in this. And so those are some of the conversations that we're going to be having. Supervisor Simon and I are going to be having with Carol to kind of flesh that out, because that really is the next logical step. And there was the park meeting, the Cobb Park meeting with Lars last night at 6 o'clock, and we had some community members get together and talk about what they want in a Cobb Park. Tomorrow I have a call with Mark Dellinger about a geothermal project. One of his clients in the Jago Bay area. A call with another constituent in the afternoon. On Thursday, Best Fits grant meeting is in the morning. Then we have our drought planning workshop, which I'm guessing tomorrow we will be developing the agenda for.
Of course. It's already pre-developed.
Okay, good. There's the COVID vaccination task force and the grand opening of Paper and Poppy in Kelseyville, which we're all very excited for. And the CIC meeting in the evening at 6:30. On Friday, I'm pretty sure I have something in the morning that I didn't write down. But in the afternoon, I'm meeting with County Council for my in-person orientation. There's a California Wildfire Mitigation meeting with the Home Hardening Initiative. And then I am going to be meeting with our treasurer tax collector for the second half of my orientation with her as well. And then on Monday, I'm having my weekly meeting with CAO Hutchinson, and then we're going to have our CMAT reporting committee meeting as well.
Thank you. Supervisor Simon.
LAFCO tomorrow morning, I think it's in Lakeport, right? I think it's in Lakeport tomorrow. And then in the afternoon, we have the AVA meeting, at 1 o'clock. That will be by Zoom. Then we have the Best Grant Fit meeting, but I have been asked to go to the grand jury on Thursday morning, so we'll be doing that. State Board of Fire Services in the afternoon on Thursday. And then later that night, have the Hidden Valley Lake Community Service District Flash meeting at 6 p.m. And I had on here the drought emergency meeting. Is that happening on Friday? I missed a couple of those. Yeah. And then Friday afternoon, have the external California wildfire, the same meeting that Jessica talked about earlier, a home hardening initiative. And so I'm going to attend that meeting. And then on the weekend, and just to talk about it, very excited about the football programs in Lake County. We have 3 teams that are in the semifinals, one in Upper Lake, one in Clear Lake, and Middletown, so pretty unique. I don't think we've ever had that before in our history, so good job to all those teams and the cheerleaders and everybody else in the schools participating in that. So good representation from Lake County. And then back here for the meeting on the 22nd, I have my meeting with Carol. And then in the afternoon, we have a CMAT reporting committee meeting. And then back here for a full agenda on the 23rd.
Getting fuller by the minute. All right, thank you very much. I'll be brief. One of the reasons I had to step out today at 12:45 is I was involved with Assemblymember Woods and Assemblymember Aguiar-Curry to discuss broadband internet and the passage of AB 14, which kind of looks at mainly disadvantaged communities, especially rural communities, and the lack of broadband access that exists. COVID-19 has obviously propelled this topic to the forefront. And I believe it was $875 million has been allocated specifically to AB 14. Don't quote me on that number, but I believe that's close to what it is. And that's in addition to $2 billion coming from the CPUC for the last mile. And as well, we have the infrastructure plan that has been passed by the federal government with, I believe, $85 billion in total broadband deployment funding availability. So we are doing what we can to make sure we're best positioned, and it's good to know that the state is focused on Lake County as far as the steps that we've taken that many other counties have not yet taken, and so it's good to be at the forefront there too, and hoping that that positions us for good, adequate funding. LAFCO tomorrow after our agenda review. After that, I'll be meeting with the Rural Arts Initiative to discuss about a Clean California program, discussing that with the city of Clear Lake. I have here that we have our AVA meeting in Clear Lake. It should be in Lakeport, right?
It's going to be Zoom.
Oh, it's Zoom. Okay, well, that takes care of that. Because usually we coincide between LAFCO and AVA, but you're right that we're on Zoom right now only. And then we'll be joining a marketing committee over in City Hall in Clear Lake. And starting Thursday with Judge's Breakfast, moving on to the Drought Planning Workshop, which will have a full agenda ready to go. And then also joining our water resource team for the Clean Water Program meeting. Then getting on the phone with CSAC, see if there's any new updates coming from the state related to COVID. And then I'm going to be meeting up with the station manager, Thomas DeWalt, for PEG to do a quick video. I'll be discussing with Supervisor Simon if I will be attending with him or not. Need to check in first, but at the same time there is a Clear Lake City Council meeting, and so we'll see where that I go for that Thursday night. And Friday starts with a drought emergency, continues with something I'm unaware of that's not popping, and then talking with a team that helps get rid of our aquatic weeds in our lake. Clean Lakes is their name, or from Benicia, I believe. And we'll be having a meeting with them and Director De Leon from Water Resources to see what kind of solutions they may have for some of our public lakeshore areas in order to move the algae away and make them much more attractive during times of drought or times of high heat. That creates a unfortunate odor that most people don't find attractive. Then I am going to be interviewed by a student from Woodland Community College in Clear Lake, and then joining Woodland Community College for their food street fair as well as their open house that starts on at 2 p.m. And again, that's for Lake County Campus, Woodland Community College, right next to Walmart and KEC. And I think that's as much as I have at this moment. And coming back on Monday, prepared for a meeting on Tuesday, meeting with our CAO, and finishing up with that. And so that will do it. And checking in again with CAO Hutchinson if there is staff to be able to take up item 8.1, and I don't believe that item should take long.
So I'd like to have your board go ahead and take it up. I have not gotten a response from the assessor recorder, but the assistant clerk of the board advises that she can do a share screen and show your board a form in which the matter was withdrawn by the Ferrigno family. And with that, your board should be able to act on it. So
okay.
If we can have the assistant clerk of the board share that document. I was not able to see that specifically in the agenda packet, so we'll have her show us that.
And so item 8.1 is our assessment appeal hearing, sitting as the Board of Equalization. The item is approve withdrawal of the following assessment appeal applications, number 22-2020, Ferrigno Family Trust, APN 039485610. And I believe that, yes, we should have that as the first attachment that was on our agenda. So that's something that we should have been able to review over the weekend as well as now. But if you can go ahead and scroll down just to see what was the approved.
Yep, there's an X. Please withdraw my appeal.
Yeah, please withdraw my appeal. I do not intend to appear at my scheduled hearing. And so then I believe there's also some, if I remember correctly, I'm opening it up, but there's also some financial stuff underneath to show the difference between, and obviously with the, nope, wrong file. So we'll go from there, and that's the request, is to approve the withdrawal. And as we can see, the person who was originally appealing had signed the withdrawal. So any questions from the board on this? Okay, the public, it's very dark in here. And see nothing from the public, and bringing it back for approval of withdrawal.
By motion, please.
By motion, please.
Mr. Chair, I move to approve the withdrawal on the following assessment appeal applications. Number 22-2020, Farino, am I saying this right? Farino
Close. Good.
Family Trust, APN 039-485-610-000.
Second.
We have a motion from Supervisor Simon, a second by Supervisor Scott. Roll call, please, Johanna.
Okay, Director Simon,
Yes.
Director Crandall,
Aye.
Director Scott,
Aye.
Director Pyska,
Yes.
and Director Sabatier.
Aye.
Thank you.
And with that, we've moved all other items. We are moving also all remaining closed session items to a future agenda. And I'm looking at CEO Hutchinson to make sure that I am saying that correctly.
That is correct, sir.
All right. And so with that, we are at item number 10. And thank you very much for joining us today for a very long conversation. And we will be adjourned and see you next week.